let's see. Let's see if we can do this. I don't need these because I'm not listening to anything, hopefully, this stream. We're doing that. We're going to do that. That over here. We're going to do that. Move you. Move you. Aha, I can move you. So we're going to do that. And we're going to do that. What's going on? Sign in to continue YouTube. I thought I already was signed in. All right. Next. Welcome to Boomer Vision, folks. I hope everybody has had a wonderful holiday. Well, no one can see me typing this stuff in. All right, there's that. I am signed in. Phenomenal. I don't know what that even means. Oh, I can see that my stream is excellent. Wow. Wow. So I have the live chat here, so I don't have to pop everybody out. For those of you who are streaming this on a small screen, I apologize that it will be small. I've said that a time or two, right? But it'll be on the screen so you all can see it if you need to see it. And I also want to do this, and I want to do this, and I want to do this, so that I could do this, and that is not the real Turtle Boy. Okay, perfect. Perfect, see? Everything's coming together. Everything's coming together. Nice try, Turtle Boy Live, if you're not the real Turtle Boy. Big time with this techno. I just, StreamYards is nice and fun and everything like that, but it requires me to click on chat every time to show it, and it's just a lot easier if I just have live chat going, right? So we're going to cover the emergency protective order. I have done a modicum of research to Massachusetts law. Massachusetts law is different than California law, obviously. So, don't expect a whole heck of a lot out of me. I have done a modicum of research. You can see that I have pulled up the cases and read them. So at least there's that. And then we're going to cover a little bit of DeCastro versus LVMPD and a little bit of Springer versus 7th Judicial District. I am going to do Springer last because the attorneys in Springer annoy the ever-living piss out of me because I think I'm better than everyone, but they are freaking terrible. They are freaking terrible. Like, I have not been impressed at all with any of the pleadings in Springer versus 7th Judicial District Court. So here is his emergency motion for protective order. Now, this should be a very tightly written document. It should say what the issues are, what the factual issues are. Am I frozen? No, I'm not. All right. I was just seeing a different screen. So I need to look at that, and then I can see that I'm not frozen. Aha. All right, so what they should do is they should set forth the facts. And then once they set forth the facts, then they should set forth what the law is. And then they should apply the facts to the law. It's the same way every time, all the time, right? And especially if they have undisputed facts, if they have facts that the state agrees to. If they don't have facts the state agrees to, well, then they got to make their best showing possible. But it's best if they have undisputed facts and then disputed facts that they can maybe attach a declaration to with maybe an exhibit of the video or whatever they're going to be relying on, etc. Right? Kate's boobs, hell yeah, brother, hell yeah. Those are undisputed facts. I can't highlight it, but hell yeah, brother. So we can see already that a 7-page document, this is not going to be a tight and well-written document. This is going to be a lot of fluff. Your audio is first-year family law training level. What the hell, bro? I show that I'm in the yellow area. I mean, if you know, no offense to you, Aaron, but I don't exactly trust you. So if someone else says that my audio is too low or whatever, if you're complaining about the sound of a dog chewing on a dog toy, it's yak cheese, apparently. If you're complaining about that noise, well, you're just going to have to deal with it. And if you're complaining about the echo, well, leather furniture and wood and no carpet doesn't really absorb a lot of sound. Audio's fine, says Seema. It's a little echo. What's going to be a little echoey. I had a choice of filming outside. It's a lovely, beautiful day outside. Lots of sun. A little chilly, but the 3 guinea fowl are in the backyard, and they were just going off. And I'm like, I'm not gonna mess around with that. All right, so everybody's saying a little echoey, but fine. It is going to be a little echoey, but we'll move through it. You're not here to listen to my dulcet tones. You're here to get a little education on the law, hopefully. All right, so now comes the defendant in the above entitled manner by and through the undersigned counsel, and respectfully moves for a protective order seeking, inter alia, a court order mandating that the district attorney and state police cease and desist from searching Mr. Kearney's electronics seized in the instant case unless and until an independent special master-headed third-party screening team, taint team, can be appointed. So again, as I pointed out, the state had already said that they were going to get a taint team installed. So I'm not entirely sure of why they need to do the emergency protective order, but we'll see. And then they cite to Preventative Medicine Associates versus Commonwealth, full bench decision from the SJC approving lower court taint team order and mandating for future cases that where, as here, targeted search warrant is indicted or complained against, or even where attorney involvement pre-charge, see footnote 12, that before any search of these emails may take place, the Commonwealth must present to a Superior Court judge and obtain the judge's approval of the search protocol to be used, and specifically the procedures proposed to protect against searches of privileged communication between the attorney, the defendant, and his attorneys. And so let's check out footnote 12. The reported question, that's the question that the case is specifically dealing with. Specifically asks whether the Commonwealth may search the post-indictment emails of a criminal defendant, but the parties have treated the question as asking whether the Commonwealth may search a criminal defendant's emails post-indictment. So there is a distinction there. So in Preventative Medicine Associates, it's not preventative, it's Preventive Medicine Associates. The defendants were arrested on an arrest warrant. And the state was seeking information on different charges. So he's been arrested on charges X, and the state is looking for information on charges Y, or to charge him for Y. And so I believe it was 3 months. Let's go back up here. I think it was about 3 months after they indicted him, they issued a subpoena to Google for Gmail accounts. All right. So the Commonwealth requested in writing that Google preserve the email accounts. Thereafter, on December 21st, almost 3 months after the defendants were indicted, the Commonwealth applied to a judge in the Superior Court for a search warrant to search the email accounts of the two defendants for documents relating to these three things, right? The affidavit in support of the search warrant did not mention the grand jury previously returned indictments charging the defendants with having operated an illegal kickback scheme with certain sober homes. So in this case, the operative facts of preventive medicine associates is that person was arrested for X. The state thought that they had also done Y. So 3 months after they were arrested for X, the state asked for the emails from Google, right? And it was fairly broad that they asked for a search warrant to get this stuff. And what Google did is Google just sent all of the stuff to the state, and the state did a what would be considered something of a taint team approach. They had a forensic guy look at all the emails and sort out all of the emails that were related to law firms that these two defendants might have been in communication with about existing charges for the first for what they were actually indicted for. And then they sent the remaining documents to the state investigator, who started going through them. And the state investigator realized that he was getting documents from emails from after the alleged acts had occurred. And so it started a kerfuffle. The defense ended up getting a copy of this. The defense raised an issue because the initial screening, because all the screening was doing was looking for emails going to specific law firms. So it missed some documents apparently. The guy who's doing the screening didn't look at what the email said, but he apparently missed some emails. And so the defense was all upset. And so here they're looking at, number one, what the court is looking at in preventive medicine is the sufficiency of the subpoena, whether it is sufficiently narrowly tailored, not narrowly tailored, that's First Amendment, where it's sufficiently specific about what they're looking for and how they can look for it. So that was issue number one. And issue number two was how the taint team is supposed to work, how the team that is supposed to prevent the state from getting all of the stuff and only the stuff that they actually applied for a search warrant for would work. And yes, I'm going to say taint a lot in this because we're dealing with taint teams. I think it's as funny as you do, but eventually we have to actually get to the thrust of the matter. So what the court determined in preventive medicine associates, I always want to say preventative, but it's preventive medicine associates. What they determined was that the taint team procedures need to have four basic things in them. The members of the taint team must not have been and may not be involved in any way in the investigation or prosecution of the defendant subject to indictment, presently or in the future. So if you're a member of this taint team, you will never, ever, ever, ever be involved with the prosecution or investigation of the defendants in the future, and you can't be involved in their investigation currently. Number two, the taint team members are prohibited from disclosing at any time to the investigation or prosecution team the search results submitted by the defendants, and B, disclosing to the investigation or prosecution team any emails or the information contained in the email subject to review until the taint team process is complete and in compliance with its terms. So they can't disclose to the investigation team or the prosecution team any of the stuff that they've gone through until the taint team process is complete, right? It's got to be completed. Number three, the defendants must have an opportunity to review the results, and that's important, of the taint team's work and to contest any privilege determinations made by the taint team before a superior court judge, if necessary, prior to any of the emails being disclosed to the investigation or prosecution team. So this is when the taint team's work is completed. The defense has to have an opportunity to contest the results. Now, this is a slightly different way that I have seen it done in the past. What I've seen done in the past is where the prosecution picks a couple people, and the defense picks a couple people, and they both kind of go through it together, and they agree together on what is or isn't protected by privilege. And then if there are any documents that they are in dispute about, whether or not they're protected, etc., then they will go in front of either, normally it's not an actual superior court judge. Usually it's a lower level, like special master, like a special discovery master or something like that. A lower level magistrate, somebody, just a neutral third party who can then look at it and make a determination of whether it is or isn't appropriately disclosed to the other party. And number 4, the members of the taint team must agree to the terms of the order in writing. So the order that says that a taint team has to do things this way, the taint team must agree to the terms of that order, saying that they're going to abide by it. And again, the issue in this, I just want to make it clear, the issue in this was that 3 months after these defendants were indicted, the state is seeking their emails, and those emails are going to have emails between them and their attorney on the charges that they were already indicted for. And so it might give the government a leg up in prosecuting them for what they are already indicted for. So let's go back to footnote 12. All right, so the reported question specifically asks whether the Commonwealth may search the post-indictment emails of a criminal defendant. So these criminal defendants were indicted, and then the Commonwealth got a search, or they subpoenaed, I believe, the Google email accounts from Google. And the question is whether they can search these emails, because these emails are going to have emails between them and their attorney, and those are protected by attorney-client privilege. But the parties have treated the question. So the parties, instead of arguing specifically the question that was in front of the court, the parties have treated the question as asking whether the Commonwealth may search a criminal defendant's emails post-indictment, which is a different question. We also consider the issue of post-indictment status to apply to the criminal defendant, not his emails. That is, the question raised concerns the emails of a criminal defendant after he has been indicted, regardless of whether the emails are dated before or after the indictment. In answering the question before us, we do not mean to suggest that the same or at least similar issues concerning email searches and attorney-client privilege cannot arise before indictment, where, for example, the Commonwealth seeks to search emails of a person who is charged by way of complaint but not yet by indictment, or an uncharged person who is a target of an ongoing criminal investigation and who is known by the Commonwealth to have retained counsel in connection with that investigation. So what they're saying is that essentially we're not ruling out that if before indictment, if you know that you've been charged by a complaint, you probably sought out legal help, and so they're going to have to make sure that they're not getting any of that privileged information. So that's 12. That's footnote 12. Now, what do they say about footnote 12? See footnote 12, that before any of these searches may take place, the Commonwealth must present. Oh, okay. So, all right. So maybe I'm misreading it. So, full bench decision from SJC, Supreme Judicial Court, something, approving the lower court taint team order and mandating for future cases that where, as here, target of search warrant is indicted, then they had or complained against, or even where attorney involvement pre-charge, see footnote 12. That's a dumb thing to put in there. I don't know why they did that. That makes the sentence very hard to read. So full bench decision, approving the lower court taint team in order and mandating for future cases that where the target of a search warrant is indicted, that before any search of these emails may take place, the Commonwealth must present to a superior court judge and obtain the judge's approval of the search protocol to be used, and specifically the procedures proposed to protect against searches of privileged communications between defendant and his attorneys, which is not contained in footnote 12. So is it up near before where footnote 12 is? What is he saying? Control F. We conclude that in the future, so this is what they should have cited to 823. So where's your fucking site, boys? Where's your site? Given the constitutional command of reasonableness, and in light of the risk involved to the integrity of the defendant's attorney-client privilege, we conclude that in the future, when the Commonwealth seizes, pursuant to a search warrant, the emails of a defendant under indictment, before any search of those emails may take place, the Commonwealth must present to a Superior Court judge and obtain the judge's approval of the search protocol to be used, and specifically the procedures proposed to protect against searches of privileged communications between the defendant and his attorneys. So the Commonwealth must present to the judge and obtain the judge's approval of the search protocol. Okay. So are they going to say that the search has actually started? That'll be interesting. Well, they're saying they have to cease and desist, which really is weird because again they agreed to a taint team already. So interesting. In compliance with the command of Preventive Medicine Super, Mr. Kearney respectfully requests 1. An order requiring the prosecution and police to cease and desist from searching any devices until further orders issued from the Superior Court after hearing. Okay. But it doesn't say that the defendant has to apply to it. It says that the Commonwealth must present to the Superior Court judge and obtain the judge's approval of the search protocol to be used. And I don't see that it actually has to be I don't see why it can't be an ex parte hearing. I don't see necessarily that the defendant has to be involved in it. It just says the Commonwealth must present to a Superior Court judge and obtain the judge's approval of the search protocol to be used, and specifically the procedures proposed to protect against searches of privileged communications between the defendant and his attorneys. Here we go. Further, unless the Commonwealth can demonstrate compelling contrary reason, the defendant must have an opportunity to be heard before the judge approves a particular search method. So they could theoretically do one ex parte if they can demonstrate a compelling contrary reason. Otherwise, it has to be a contested hearing. Okay. The appointment of a taint team headed by a court-appointed special master to screen the search of his devices and shield privileged materials from investigators. That's not required. That is not in compliance with the command of preventative medicine. The taint team necessarily has to agree to the order, but it doesn't have to be. It does not have to be. There doesn't have to be a special master. So the prohibition is that they can't be involved with the investigation or prosecution presently or in the future. That's it. That's it. So this is an ask. It's not mandated. This is just an ask. That since the Norfolk County District Attorney is conflicted out of the case, has appointed a special prosecutor, and is therefore not an appropriate source for a taint team, that a third-party special master be appointed at the Commonwealth expense. The entire Norfolk County District Attorney conflicted out. Interesting. Interesting. I wonder why. Well, I don't. Let me rephrase this. I don't really care about this particular case. I'm just reporting on it because so many people have just bugged the living shit out of me about it. So I don't really care, but it's interesting that the Norfolk County District Attorney conflicted out of the case. But they still don't need a third-party special master. It just has to be people who aren't involved in the investigation of Turtle Boy in the present, and then they won't be able to be involved with him in the future in the investigation or prosecution of him. The return of the devices. Oh wow, this is a big ask. The return of the devices, since upon information and belief, mirror images of the contents have been taken according to standard investigative protocols for attention and analysis by the police, rendering the continued seizure unreasonable under the Fourth Amendment and Article 14 of the Massachusetts Declaration of Rights. Well, how do they know that? How do they know that? How do they know that? And on information belief, like on whose information and belief? I did not receive. Maybe there was a declaration that was submitted with this, but none of you cared enough, or all of you did care, but were too fucking lazy to put it into my Discord. So I haven't read any declaration that went along with this. So whose information and belief are we dealing with here? And how good is the information and belief? So normally, when you're saying something on information and belief, you want to say why you have that information and belief. Usually it's going to be some third-party hearsay. Is this information and belief just because the standard investigation protocols for attention and analysis by police may require them to make a mirror image of the contents? And if so, have they made the mirror images of the contents? So, like, why don't you state like which investigative protocol it is? Like, according to the whatever, I don't know which police department. We'll just say according to the Boston Police Department rules of or policy for handling electronic device evidence, we do X, Y, and Z or something, right? And so the question is, like, how do they know a mirror image was taken? Number one. And number two, how do they know that the mirror images are accurate? How do they know it's going to work? I mean, if they haven't gone through these things yet, how do they know that they actually got everything? And how do they know that it's a standard investigative protocol? The provision as required by preventative medicine, I thought all of these were required by in compliance with command. Now the one thing that is apparently going to be actually required by preventative medicine, the provision of all data reviewed by the taint team segregated by presumptively privileged material and reviewable material for review and comparison by defense. Well, I mean, if you have your guy on the taint team, didn't they ask to have their guy on the taint team? But yeah, they are supposed to segregate the presumptively privileged material and the reviewable material. All right, introduction. Now here's where you get all the bullshit. Mr. Aidan Kearney is an investigative journalist. They didn't say award-winning this time. They left out the award-winning. Is an investigative journalist who owns, reports from, and operates a number of news outlets that broadcast over the internet through YouTube, Facebook, and his own websites and web pages. He live streams news, investigates serious matters of public concern, and often breaks stories before viewers' very eyes live on the air. Oof, hard hitting. He offers pointed and unapologetic commentary to his viewers, which number in six figures and cumulatively reach into the millions. He protests urges boycotts, engages in political hyperbole, satire, rhetorical confrontation, rallies his supporters in the field, chases down witnesses and investigative targets wherever they may be found, petitions the government for redress, and exposes corruption by government officials. He practices advocacy journalism and provides in-depth, well-sourced, factual reporting, often accompanied by a call to action for truth, or for justice and truth. Police, prosecutors, and some jurists do not like his methods and disagree with his opinions and conclusions on particular matters. For the first time in Massachusetts, and possibly the country, these police and prosecutors in the Stoughton District Court have decided that time-honored journalistic tactics and hard-nosed investigative reporting may now be criminalized into felonies. It always bothers me when, say for example, a auditor will go into a post office and start yelling and screaming and throwing a fit, getting up in people's faces, and being a generalized asshole. And then he gets trespassed, gets kicked out. And he's like, oh, they kicked me out because I was recording. They kicked me out because I was filming. And you're like, no, asshole. They kicked you out because you were being an asshole. Like, if you did the same things, except without a recording device in your hand, you would have achieved the same results. It's not because of the filming. It is in spite of, extraneous to you filming, right? Turtle Boy is making the exact same argument, or his attorney is. The attorney is again arguing, despite now two judges apparently looking at the allegations and deciding that a crime probably occurred, because again, there was an arrest warrant issue. So some judge, magistrate, whatever you want to call him, issued the arrest warrant. That judge said a crime probably occurred, and Turtle Boy is the guy who probably did it. And now a second judge, the judge on the bail rehearing, said, you know what? A crime probably occurred, and you probably did it. So now we've had two judges look at it and decide that it wasn't just reporting, and he's still arguing that it's reporting. Interesting. Like, you know, this is written not for the judge. This is written for Turtle Boy. His attorney wrote this for Turtle Boy. He's sucking his client off. He knows he's not going to get. I've worked with attorneys who do this. They'll write in whatever the client says into the moving paper, whatever the client says, and they'll go up in front of the judge and they'll bang on that attorney table and they'll argue exactly what the client wanted them to say, and then they lose, and then they walk out of court and they say, "Boy, didn't you see me up there fighting for you? You know that judge, boy, he's a big dummy, boy. But I fought for you, right? So make sure you pay my check, right?" It's exactly that. So this is written, just so that you guys understand, this is written for the client. This isn't written for the judge. This isn't going to impress the judge. The judge is going to glaze over this and skip past it. Well, he's not going to skip past it, but he's going to glaze over. You know, whatever. Okay. Get to the facts. You made allegations on information and belief. Give me the facts that are going to support what you had to say. Give me the law that says that you're entitled to what you say you're entitled to, and let's go on from there. The preventive medicine, that's a good case. That means you're entitled to a taint team. But we've got the state already saying that they're going to work with you, or they're not going to look at anything until they have a taint team. You said, it's Turtle Boy's attorney said. Turtle Boy's attorney said that they're going to that the state agreed to a taint team. Let me just make sure I have it. Is it? I think it's this one. Page 2. The government has agreed to cease further intrusion into Mr. Kearney's devices pending litigation on the appointment of a taint team to shield Mr. Kearney's sources and materials. So the court's going to be like, let's get to this. Like, give me the facts, give me the law. Explain to me why you need this. Explain to me why you need this in this fashion. Why are you hurrying the state's case along? Here, Mr. Kearney has criticized, embarrassed, and exposed wrongdoing by investigators working on a particular criminal matter pending in the Norfolk Superior Court. The same group of investigators from state police assigned to Norfolk District Attorney's Office has now utilized the witness intimidation statute against Mr. Kearney in a brazen effort to silence him on the very same case they are prosecuting. So there's three groups of people that he's mentioning here. Three. The investigators working on the particular criminal matter. Those are going to be the police. In California, they do have investigators assigned to the prosecution's office, but they're functioning as police. They carry firearms. They have badges. They're basically police, but they're just kind of investigating at the direction of the prosecution, the DA. So that's one group of people. You got the police, investigators, the police. And then, so same group of investigators for the state police, yada, yada, right? So he says the state police have used the witness intimidation statute against Mr. Kearney in an effort to silence him, but it's not them. It's going to be the DA. That's number two. The DA has used the witness intimidation statute against Mr. Kearney. Why they did it, I don't know. Don't care. But it's the DA who did it. The DA is the one who is prosecuting this case against Turtle Boy. And then the third person that they're implicating in this is the judge who signed off on the arrest warrant. Is that judge so you Turtle Boy shit all over the investigator. Great. So the investigator doesn't like you. Great. And that's great. Let's just assume arguendo that these investigators give two shits about you, Turtle Boy. Arguendo. I doubt they do, but let's just assume arguendo that they do. Now explain why the DA hates you. Quote, air quotes, hates you. Explain why they're trying to, in quotes, silence you. Explain that. No, it's even better. So apparently the Norfolk District Attorney's Office has recused themselves. They've conflicted out. They said they can't prosecute you on this. So now it's some third county or special prosecutor who is unrelated to any of this. He is prosecuting this case against you. Explain him. Explain why he is doing this against you. If it's not that there's probable cause that you violated an actual law, if it's not that there's a reasonable chance that he's going to be able to prove beyond a reasonable doubt that you did violate the law, why would he be pursuing this? Why would the judge, who has no interest in this whatsoever, he's going to get the same pay whether he agrees, disagrees, whatever. He's going to, it's going to be a jury who's going to be, you're literally just wasting if it is what you say, the prosecution would literally just be wasting the court's time. And why doesn't your attorney just file a motion to dismiss? Why doesn't he just file a motion to dismiss? Why does he file a motion saying that there is no probable cause? That even if everything that the state has alleged in the criminal complaint is true, that you still win as a matter of the First Amendment. Why doesn't your attorney do that? Oh, it's because it won't fucking work. Could it be? Could that be? I'm guessing that is. So right now we're dancing around bullshit. We're playing bullshit games and winning bullshit prizes because your attorney is on the milk truck. Milk truck to survive. So yeah, this whole the investigators, I guess, for the first time, have used a witness intimidation statute in an unprecedented way for their own personal benefit to stop Mr. Kearney in the exercise of his fundamental right to speak out and petition the government for redress under the First Amendment. And again, what personal benefit is the special prosecutor getting? What personal benefit is the judge getting? Because remember, those two are also involved in this. And how are they stopping him from petitioning the government for redress of grievances under the First Amendment? This is a fucking motion. This motion is literally a petition to seek redress of grievances. The other motion, the motion on the bail hearing, was a petition to the government for redress of grievances. They're saying it was him saying, I am entitled to X. Government, give me X. I don't know why people think that petitioning the government for redress is solely limited to marching or protesting. That's the least effective form of petitioning the government for redress. I mean, like you could, the words sometimes give you the context. Petition the government for redress. Well, in the law, you could file a petition for redress. You could file a petition asking the court, asking the government to give you something. They have seized the tools of his trade by ransacking his home and seizing his phones and computers. They have arrested him at his children's bus stop. Again, who fucking cares? Who fucking cares? And they have perverted the use of an already unconstitutionally overbroad statute to suppress his voice and ability to investigate. Except, a judge has already ruled, a superior court judge has already ruled that the statute is not unconstitutionally overbroad. It might have been ruled on appeal as well, because again, where's your citation to anything? It's just like he's just shitting into his hand and throwing it at the computer screen. That's essentially what he's doing. This is Chilli level writing, and this attorney is capable of better. The reason why you're seeing this is because he is talking to Aiden. He's talking to Turtle Boy. He's saying, I agree with you, Turtle Boy. That statute is unconstitutionally overbroad. And he pats him on his tiny little head. Yes, I agree with you, Aiden. As long as your check's cash, I agree with you, Aiden. It's unconstitutionally overbroad. We filed one motion where we broached the topic ever so slightly, and the court said, as applied, it's still good, bro. But where's your motion? Where is your motion to set aside the statute is overbroad? Where's your motion on this? Oh, there is one. Why not? Why not? We're going to allege it for Aiden, but we're not going to actually fight on it because that's a fucking loser. And that might, I doubt it. I was going to say it might expose him to, it might expose the attorney to potential sanctions for a frivolous appeal or whatever, but I doubt it. I think if you find it to challenge it, I think you get a lot of leeway on that. So I'm going to walk back what I was going to say. How about that? And then I told you what I was going to say, so I actually said it. But you get what I'm coming at. Privileged material at risk. Now, privileged in the law is a specific term. There are, generally speaking, privileges are going to be either common law privileges that have been passed down from time immemorial, or they're going to be statutory privilege. Your basic privileges are going to be like your attorney-client privilege. The court most likely won't, or opposing party most likely won't be able to get anybody to testify about what was said between the attorney and the client. I mean, I'm going to, hashtag not all, but the odds of you getting through the attorney-client privilege are somewhere between slim and none. Other common ones are the spousal privilege. You can't force a spouse to testify against their spouse. Now, there are some exceptions to that, like in domestic violence cases and things like that. But generally speaking, there's a spousal privilege. There's the priest penitent privilege. You can't force a priest, pastor, rabbi, whatever, imam, to testify about what one of their worshipers came and told them. The psychotherapist patient or therapist patient privilege. You can't force a psychologist to testify about what their client said. Those are the big ones. There may be other statutory ones, but it's not a long list. Privilege is a term of art. It means a specific thing in the law. Mr. Kearney's phones and computers, quote, the devices, end quote, are full of attorney-client privilege communications and materials from matters in 2 superior courts and 1 district court. Now, I did read several cases on preventive medicine, cases that referenced preventive medicine. And I could not find much about protecting beyond what preventive medicine talks about, where you have an ongoing criminal case and then another one is in the works. That's the only one that I can see. So, but there are other cases where attorneys have been charged and their computers are full of attorney-client communications, and the court has declined to offer the same attorney-client privilege to those. So it is questionable to me whether or not any attorney-client privilege communications are going to technically be allowed to be screened out by the taint team, or if it's just going to be attorney-client privilege communications regarding criminal matters that he has been charged in or arguably could be charged in. Now, I would bet that the court and the taint team are going to err on the side of caution, because these other attorney-client communications probably aren't what the state is looking for, and I haven't seen the subpoena or the search warrant, excuse me. So I don't know exactly how specific the search warrant is. But I got distracted. I read a comment from Cobb. So where was I going? Okay, so I haven't. So the search warrant has to be specific on what they could look for and how they could look for it. The Massachusetts has not yet addressed, at least that I can find, the plain view doctrine as far as like if they're looking through emails to look for a specific thing, if they find something else. So normally, like if you have a warrant to search a house, say for a giraffe, someone stole a giraffe, right? And you think the giraffe is located in Bobby's home. So you're the cop, you go to the judge and you get a search warrant to search Bobby's home for a giraffe. And you step inside Bobby's home looking for the giraffe, and you see right on the coffee table a big pile of Colombian marching powder. Well, that's what's called the plain view doctrine, right? The cop can seize that, and you can charge you for having that Colombian marching powder in your possession. And if you try to suppress it, the court's going to say, well, plain view doctrine applies. He was there on a lawful warrant. It was out in the open. He didn't search somewhere that he shouldn't have been. He was where he was allowed to be under the warrant, and so it's allowable. That kind of thing, the Massachusetts courts apparently have not determined yet as far as electronic communications go. So don't know how it's going to work out there. But the search warrant has to be specific about what the cops can look for and are looking for and how they look for. So there are also privileged communications regarding attorney-client consultation on the legality of matters raised in the instant case as well. So I think the safe thing is that any communications between an attorney and Kearney probably going to be weeded out. In addition, there are a plethora of other privileged materials on the devices relating to, quote, thousands of confidential sources who have sent me information and tips for stories under the condition of anonymity. All of these sources are in danger of being exposed and their privacy violated, end quote. I don't know what he's quoting, but there is no reporter's privilege. And you can see that in what the petition for promulgation of rules states. And they state in here somewhere that they are asked to find or to create a reporter's privilege, and they decline to do so. We decide that, assuming this court has the power to establish by rule a reporter's privilege, the exercise of that power is not warranted in the present circumstances. There is no reporter's privilege in Massachusetts. So this part about him wanting to protect, quote, privileged, end quote, materials is they're not privileged. There is no privilege to his confidential sources. Will Bauman says, "Oh, he's quoting TB. Is he? I don't know. Where's anything? There's no footnote. There's no declaration attached to this. So what is he quoting? You don't know. I don't know. I do want to see if anybody, and nobody has posted anything in my open docs or curated docs about a declaration from Turtle Boy. So I don't know what he's quoting, and you don't know what he's quoting. This includes, and then in italics, just so that everybody's aware of it, police sources from past cases and current pending cases Mr. Carney's covered. No privilege. That's not privilege. We are talking whistleblower anonymity type shit almost. It's not whistleblower shit to go to the press. Is it? I mean, is there a statute in Massachusetts extending whistleblower protection to being an anonymous reporter to the press about what's going on in current and pending cases? I'm not aware of it. Well, you know what, Biff? That sounds like a fucking you problem, not a me problem. You guys are the fuckers who want me to cover this. I could have gone my whole life without dipping one more toe into Massachusetts dumb fuckery. So don't come to me with that mess. Like, if you want it, you fucking dig for it. The more information you get me, the better quality my analysis will be in the long run. So fuck off with that nonsense. And I know Kate is out there. I know Kate gets every fucking document that gets filed in this case because she is an interested person in it. Not an interested party, but she's an interested person. And she's just waiting. She's just waiting for Aiden to go to jail. Well, Biff, that's a stupid argument because Kate fucking lives there. Massachusetts isn't that fucking big. Yeah, you better get on it, Biff. Get fucking... I sound horrible. I'm sorry. All right. These very investigators, whom he's exposed on the Karen Reed murder case, quote, will now be able to find out the identities of their colleagues who bravely stepped forward to offer up information on their coworkers. Why were we offering up information on coworkers? Is information on coworkers relevant to the Karen Reed case? I don't know. I don't really care. But again, is this news? Like, why is this privileged? Where's your citation of why the fuck this is privileged? If they are allowed to avoid required court hearings analyzing the applicability of the journalist source privilege. What journalist source privilege? What? Where citation fucking needed? Now, see here, they cite to petition for promulgation of rules, right? This is the petition for promulgation of rules. There is no reporter's privilege. The task force was created to say the need for a press shield law in Massachusetts, right? They're looking for it. As suggested by the task force, the scope of the privilege would extend to the organized media to include all private individuals connected with processing news, yada, yada. The privilege would protect compelled disclosure of the identity of confidential sources and unpublished information. And the court fucking decided that it was not privileged. After careful consideration of the issues presented by this position, we conclude that, even if this court does have the power to do so, it should not be exercised in the present circumstances. Instead, we reaffirm our decision to consider the gradual development of case law in this through case-by-case adjudication of the common law process. They don't create a reporter's privilege. And there's no citation here to suggest it was. So this flies in the face of the requirements of the First Amendment and Article 16 of our Declaration of Rights. How and why? Before ordering a reporter, now listen to this. Listen to the sentence. This is an important sentence. The words have meaning. Before ordering a reporter to divulge a source and the information gathered, i.e., before requiring a reporter to testify. I'm looking. Thank you, Chaos Warden, but I looked up this petition for promulgation of rules, and I couldn't find anything where they actually created a reporter's privilege. So I appreciate you suggesting that, but I'm pretty sure that there is no reporter's privilege. And if there was a reporter's privilege, I'm pretty sure that Turtle Boy's attorney would have cited the case. So now listen, remember, before ordering a reporter to divulge, i.e. before ordering a reporter to testify, to divulge a source and information gathered, a judge must consider the effect of compelled disclosure, i.e. testifying, on values underlying the First Amendment and Article 16, petition for promulgation of rules regarding the protection of confidential news sources and other unpublished information. Accordingly, a judge must balance public interest in the use of every person's evidence against the public interest in protecting the free flow of information. This is a matter of a John Doe grand jury investigation. So, in this particular matter, what the court was looking at is whether or not a grand jury could subpoena a third-party reporter to testify in front of a grand jury. There was a murder. It was a guy killed his wife and child, I think, and he set it up to look like a murder. And he tried to frame a black guy or something like that. And then his brother helped him out. And then his brother testified or leaked it. And then the guy who did the murder killed himself. And then the grand jury was looking at trying to charge the brother and I think another guy with the brother, if I remember correctly. And they wanted to get this reporter who testified. Here we go. That the story said a Stewart family source told the Herald that John McMahon was with Matthew Stewart, when Charles tossed the bag in the car, but McMahon did not play it. So they tried to get this guy to testify to the grand jury. News reporters do not have a constitutionally based testimonial privilege that those citizens do not have. There's no such statutory privilege, nor is there any rule providing such a privilege. We have, however, recognized that common law principles must justify the denial of enforcement of grand jury summons issued to a news reporter. So we're looking at a grand jury summons issued to a non-party news reporter. This is not the same thing as a search warrant. They're not trying to get a third party to come up on the stand and testify about confidential news sources. They are trying to go through Turtle Boy's computer to find out what Turtle Boy did or didn't do in the furtherance of these alleged crimes that he's alleged to have committed. So it's inapposite. It doesn't apply. See also AOSH versus Dana-Farber Cancer Institution, which is a civil case. This is a civil case. In this particular civil case, there was the Globe. There was a Globe Press or something like that, where there was a discovery. The plaintiffs wanted to get discovery from a defendant, Globe Publishing, Globe Press. Globe Newspaper Company, publisher of the Boston Globe. And so there was a discovery dispute, and despite being ordered by the court to turn over these documents, this discovery, Globe didn't do it. Globe did not turn over these documents. And so the court issued sanctions, issued basically terminating sanctions. He said, fine, you can't present a defense on these issues. And then in the appeal, Globe, well, there's a cross appeal going on. So the plaintiffs appealed and both defendants appealed. And Globe's position was we shouldn't have to, we shouldn't have been punished for not revealing or for not producing the discovery, right? And then they're talking about footnote 33. So let's go down to footnote 33. And you can see it's a discovery dispute in footnote 33 because it references it. This is clearly not a case where the Globe defendants were unable to comply with the orders, the discovery orders. We do not suggest their refusals to obey the discovery orders, were in bad faith. Despite their assertions to the contrary, however, the Globe defendants have no special constitutional or statutory testimonial privilege based on their status as a newspaper publisher or reporter that would justify their refusals to obey the orders. We have recognized that values that underline the First Amendment to the United States Constitution, Article 16 of the amendments to the Massachusetts Constitution, may give rise to a common law privilege that would allow a newspaper reporter to refuse to reveal his sources. Again, this is different from, hey, they seized my computer looking for evidence of a crime, and they get to go through my computer looking for that specific evidence of a crime. In deference to the effect that compelled discovery has on free speech and to avoid the needless disclosure of confidential relationships, our judges require judge ruling on discovery requests on showing that the asserted damage to the free flow of information is more than speculative or theoretical to conduct a balancing test between the public interest in every person's evidence and the public interest in protecting the free flow of information. Now, this is discovery in a civil matter. Typically, the way discovery in a civil matter works is you send the other side your interrogatories, your request for admission, your request for production of documents, etc. They'll produce whatever they feel like they need to produce in response. And then if you don't think they have produced enough, you go to the court and you say, I asked for X, I'm entitled to X because of these reasons, and they didn't produce X. And then they'll say, well, we didn't have to produce X because of these reasons. And then the court's going to make a decision. And that's what happened in this case. That's different than a investigator going to a judge and saying, I need a search warrant for this. Here's the reasons why I need a search warrant for this. And the court saying, hey, look, you do need those reasons. Here you go. You get a search warrant. There is no, it's a different process, different rules, and it's not a discovery request, so it doesn't apply. Further, there are also reams of exculpatory evidence that need to be accessed from Mr. Kearney's devices critical to establishing his defense herein. Well, here's the thing. The state must give the defendant not only all of the documents and evidence that they intend on using to try to convict the defendant, but they also have to give him all of the evidence that might help him exonerate himself. Okay, so they're going to get the exculpatory evidence. Because I don't know what their argument particularly is here. HIPAA, private medical documents and communications. HIPAA applies to very specific entities. They're called covered entities. I forget which ones they are, but they're basically, if there's a plan or healthcare provider, a healthcare plan provider, or another kind of plan provider, the healthcare provider themselves, and there's another one, the insurance, right? So these specific entities have to abide by HIPAA. It's like Health Assurance Privacy something Act. And it applies to, so it doesn't apply to search warrants. It doesn't apply, it doesn't apply. And I don't think they're going to be looking for HIPAA private medical documents unless, because I haven't seen the search warrant, but unless these what if these HIPAA private medical documents belong to the victims? Yes, there is specifically no reporter privilege in Massachusetts, at least not yet. Countless materials Mr. Kearney needs to access for ongoing unrelated stories he's working on. Well, that sucks. Every defendant ever who has had electronic devices seized by the government really could have used those electronic devices to continue doing their day-to-day activities. Every single one of them. Like, imagine you get your phone taken. You'd be like, well, I need my phone. I have all my contacts on my phone. I have, I have all these documents that I need to do things with in my life. I keep my grocery list on my phone, etc. So that's a non-argument. And many completely irrelevant and immaterial friend and family communications, sensitive and private in nature. Well, yeah, but I don't think the state is particularly interested in irrelevant and immaterial friend and family communications, are they? I wonder if his jerk off videos are also on those. I wonder if he's just really scared of the. Well, I'm sure the cops already have all of his jerk off videos, right? I'm sure they do. What are we asking for again? So this is all. They haven't asked for anything yet. They just said there's privileged materials at risk. They haven't asked for anything. Okay, search warrant. All right, we're on to the search warrant. The Commonwealth has violated the command of Preventative Medicine Supra. In their zeal to suppress Mr. Kearney's voice, they have willfully ignored the law, failed to assure any court that privileged communications exposed in the search will be protected. Well, again, that's right there. That sentence is for Turtle Boy. In any event, under preventative medicine, this process must be done with the involvement of the defendant and of the court and cannot be satisfied ex parte. Well, we've already seen that it could, in theory, if the state has compelling reason, be satisfied ex parte. The state would require a compelling reason to do it. The plan apparently has to be set forth in front of the judge. Where was it? Where was it? It was like 26. It was like 26, right? While the rules of Massachusetts Rule of Criminal Procedure do not preclude the Commonwealth from seeking ex parte warrants to conduct a post-indictment search. Huh! Where was it? Well, if I remember correctly, the particular motion has to be should be done not ex parte. Search warrant. Search warrant. I don't want the search warrant. I wanted. I don't remember what it is, but I remember reading it. So you'll just have to go back to where I read it. Yes, Alpha Fox Adam. I'm sorry. I should preface everything with hashtag not all. But it certainly doesn't apply in this case. Can we agree on that? Goddamn attorneys and almost attorneys in my chat. Bastards. Hashtag not all. All right. So they in any event, under preventative medicine, this process must be done with the involvement of the defendant and the court and cannot be satisfied ex parte. Defendant's involvement in the review procedure in particular is a crucial check against the potential for mistakes or abuse by the team. 828. Let's look at that. 828. Oh, I have the other version of it. I have the NE version. I don't have the. Ooh, what's this one? Oh, I got it. We're just gonna blah blah blah. Oh. Further, judicial supervision is essential where the Commonwealth seeks to search the emails of an indicted defendant because of the risk that privileged attorney-client communications will be included in those emails. we've already determined that they have to get an order from the court, and they also had agreed. I mean, they've already acknowledged they needed litigation to get the order, right? They've already acknowledged it. I don't understand how they violated it if they've already agreed it. And again, this isn't the state saying that we've agreed to this. This is Aiden's attorney. This is Aiden's attorney saying it. Timothy Bradle. Aiden's attorney said that the state has already agreed to litigate the issue of the taint team. Just fucking irritating. Before any search of those emails may take place, Commonwealth must present blah, 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 supervision necessary further. Yeah, there we go. Further. Yeah, I knew it was there. Further, unless the Commonwealth can demonstrate a compelling contrary reason, the defendant must have an opportunity to be heard before the judge approves a particular search method. So it could, in theory, be done ex parte if they have a compelling contrary reason. And then relief requested. The Commonwealth has placed the court at a crossroads. They have ignored black letter law. Is black letter one word? I don't know. They've ignored black letter law in place, and wouldn't it be African American law? That's a joke. They've ignored black letter law in place for the protection of fundamental rights. Court intervention is needed to vindicate First Amendment, Article 16, the rights of journalists. Again, there is no journalist privilege, reporter's privilege. The reporter's fundamental right to defend himself and seek counsel. It's your fucking attorney who is, well, to seek counsel. I guess technically violations of the attorney-client privilege might be perceived of as Sixth Amendment violations. And the right to petition of government for redress against an unlawful seizure. Well, okay. Here the Commonwealth. So why are you challenging the search warrant? You're saying the seizure was unlawful. Where is your motion to suppress based on a faulty search warrant? Where's the motion to suppress? Because if the seizure was unlawful, your remedy is to file a motion to suppress the evidence of it, to quash the warrant, and to have your items returned to you. If it's unlawful, you fucking litigate it. Why aren't we litigating it? It's just annoying that he keeps throwing this shit out, and I know he's doing it to placate his client, but it's just annoying that he's making all of these allegations and assertions, and he's not doing fuck all to vindicate those allegations and assertions in front of a court, which is where he's supposed to do it. You don't just say, "Oh, it's unlawful," and then fucking move on. You say it's an unlawful seizure, and here's my motion to quash the warrant, to suppress the evidence obtained as a result of the warrant, and to have the items returned back to my client. Here the Commonwealth, blah, 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 brazenly trampled all these protections, completely foreclosed its duty to do justice and support and defend the Constitution. Judicial intervention is legally required, necessary, and appropriate, ordering the Commonwealth to cease and desist, allowing return and access to Mr. Kearney's devices. Yeah, good luck on that. And ordering a Superior Court hearing at which a special magistrate should be appointed to protect Mr. Kearney's privileged information as set forth above. Therefore, he requests. So, Nima says, why is Aiden paying his lawyer six figures? Well, let me just put this wrinkle in. First of all, you don't know how much he's paying his lawyer. You know why? It's because that is fucking privileged information. So Aiden might have paid his lawyer $1. He may have paid his lawyer $1 million. He may have paid his lawyer somewhere in between. You don't know. The nature of what that payment is. Is it a retainer? Is it a fixed fee? You don't know, and I don't know. The billing rate. Is it a fixed fee billing? Is it a hourly against a retainer? You don't know. I don't know. So asking questions like, why is Aiden paying his lawyer six figures? It's a nonsensical question. And I don't care if he said on stream it was six figures. Again, I haven't caught him in a lie, but I don't trust him. Saying that of the Massachusetts crew, he's the only one I haven't caught in a lie. So when everybody else calls him a liar and suggests that Kate is somehow pure and virginal, as white as the driven snow, or that Shiz is pure and virginal and white as the driven snow, minus the freckles, I think Shiz really is white as the driven snow. But that's neither here nor there. I don't trust him. Him saying something on stream means fuck all. It means fuck all. Show me the fucking money. Don't tell me, show me. I don't understand why all of you believe what people tell you. You're all fucking idiots. You just believe what your own side tells you. I mean, you could believe or not believe. I fucking showed you the goddamn rulings and shit. So, I mean, but don't believe what I say, you know? I'm not. Believe what people can believe what people do, not what they say, and figure out what they do by watching what they do. Well, Kate, I can fix that probably if you're into that kind of thing. So there is not a lot here. Again, I do think that there will be a taint team. I mean, that's just plain. There will be a taint team. The taint team will definitely filter out any emails about ongoing criminal matters. They will probably filter out any emails or communications, not just for ongoing criminal matters, but any communications with an attorney. They will probably do that. So I would expect that. That was just expected. There is no reporter's privilege. I don't think he's going to win on any of the allegations that he's somehow that his communications about police and investigators, etc., are somehow privileged. He's not going to win on any of that. I don't think. I haven't found any reason for it. So, and there may be a special. If I was the state, I wouldn't mind a special maester appointed. It would be quicker and faster than trying to get in front of a superior court judge to fight over any questionable documents. But yeah, so he's gonna win some. He's not gonna get his shit back, at least not right away. They don't even address in this motion at all the information and belief that the mirror images were taken. They haven't shown that at all, or they haven't addressed it at all. Oh, they've done one of these. Okay, here we go. So this is that's Chilli levels of declarations, but I guess technically it works. I don't know. I'm not up on Massachusetts. In California, you have to do a separate declaration. So I don't know. All right, moving on. Moving the fuck on. Well, I guess there's only two things in the Castro versus LVMPD. There's a scheduling order. It's pretty simple. The parties agreed to a joint. They stipulated to a joint discovery plan and scheduling order. So the important things are the LVMPD defendants already did their initial disclosures. Initial disclosures are where they give the other side all of the documents and things that they intend to rely on, or that they are aware of that they intend to rely on. In California doesn't have initial disclosures. California, you have to ask for everything. But in the federal courts, they really just you got to give the other side everything you plan on using. And so, well, yes, Aiden, show me the invoice. I mean, it's what's fucking hilarious. What's fucking hilarious is that I've seen invoices on Wish, and I can't tell you the number of turtle riders who've come in and tell me that Kate's pocketed all that money. No, she's a fucking idiot. She's a complete fucking idiot. And she gave all that money to Wish. She's a complete fucking idiot who gave all the money to Wish. She didn't pocket it. But then, like, you haven't seen any invoices from Turtle Boy, have you? If you've seen invoices from Turtle Boy, great. Show them to me because not just, yeah, show them to me. Show me a monthly invoice sent over from Aiden's attorney because that would show you how the billing arrangement is worked. Yeah, confirmed idiot. Yeah. I've ragged you on it forever about it, and I never intend on letting it go. That was the dumbest goddamn thing I've ever seen anybody do. That was fucking stupid. So, why is his attorney from a personal injury firm? Why not? He's an attorney. I mean, that's loquificence layer. That's like people saying that you're a family attorney, right? This attorney seems to know what he's doing, but he is playing to aid. He said he was all paid up, but then still e-begging. Well, right. The whole thing on the e-begging is because it's probably a fucking retainer, and I'm sure that Turtle Boy's attorney is fucking burning through the cash. Burning through the cash. Are you still blocked? Did I ever block you? Who the fuck are you? Why would I block you? I don't even know who you are. Sean Hawkins? Shill? Oh. I fucking seen you post. You called me like an asshole or some shit on you're like, I know you. You're the guy who said like happy Thanksgiving, asshole. Hold on a second. And I hearted your post. I know you. I won't look it up. I want to be important. Am I still blocked? Hold on. Let's. How do you do that? You go to YouTube Studio, and then what was it? Settings, community. Oh, oops. Hidden users, approved users. I don't know. I'm gonna guess you're not fucking blocked, home squatch. You blocked me at one point. No, I probably did something like this. And we're going to do... oh. This doesn't have a timeout? No, I don't know how to time you out on this. I would time you out, but I can't figure it out. Being ignored doesn't mean you're blocked. It means you're worthless to the person you were trying to get the attention of. That's right. You used to tag me all the time in my mentions. That's right. That's right. That's right. Block you. Where are we doing? Oh yeah. So as far as Turtle Boy goes, show me an invoice, redacted or otherwise. Show me an invoice, redacted or otherwise, and then we'll talk. All right. So they have their pre-discovery. The LVMPD defendants have already done it. Chilli has to do his by the 27th. He gets a couple weeks of knowing how to do it by looking at what the LVMPD defendants did. If he doesn't do it right, he could theoretically not be allowed to present evidence at trial if it makes it to that point. They've agreed to meet and confer prior to expert depositions to discuss settlement options regarding any and all parties, including any new parties. The parties agreed to discuss trial by a magistrate judge. So magistrate judges are, by default, they only deal with non-dispositive motions. But you can agree, you'll get to trial faster if you agree to do it by a magistrate judges, because there are a bunch of magistrate judges and there are very few actual district court judges. You have to be approved by Congress. You have to be You have to be appointed by a president and approved by Congress to become a district court judge. So there's never enough of them because politics has to get involved in everything. How are you not sick of Chilli yet? Who says I'm not sick of it? I'm following a Chilli case, and I'm following it because it hasn't gone to completion yet. I don't watch his shit. Electronic evidence. They discussed whether they intend to present evidence in electronic format. While no stipulations have been reached, parties will present evidence in electronic format to jurors for purposes of jury deliberation. So they're going to give them the videos and stuff on like a thumb drive or whatever, so the jurors can take it back into the jury room and view them during their deliberations. So discovery will be needed on all of the following subjects: all the claims set forth the plaintiff's causes of action, as well as expenses relevant to the action. Discovery must be completed by May 15th, 2024. So they've got 6 months. They have until April 15th to file a motion to amend pleadings or add parties. So a month before discovery completed, they can file motions to amend, completing, or add party. And then expert disclosures. Parties shall disclose their experts 60 days before the discovery cutoff. The party shall disclose their rebuttal experts at least 30 days after the initial date for disclosure of experts by April 15th. So experts are the people that they're going to have to So in theory, in order to prove his case about any harm that he has experienced, to prove his damages, Chilli's going to have to get a doctor to testify as to what damages Chilli has incurred as a result of the excessive force he's alleged the police have done. I don't know if Chilli understands that yet, but good luck to Chilli. You don't want to take this to trial because you'll lose. Try to settle it if you're capable of it. Dispositive motions. Dispositive motions are like motions to dismiss, motions for summary judgment, things like that. This is 30 days after the discovery cutoff date and does not exceed the outside limit of 30 days following the discovery cutoff date that LR 26-1 presumptively sets for filing the dispositive motion. So they have up until 30 days after discovery ends. That means when they do their motion for summary judgment, they know all of the evidence that opposing party is going to present at trial. And, if it's not worth going to trial, then let's just get it done with a motion for summary judgment. Pretrial order shall be filed by July 15th, and the date is suspended if dispositive motions are timely filed, etc. Interrogatories and depositions, they agree to the customary total of 25 per party. That's pretty low. California, you get 35 specially prepared ones. I forget exactly because all you have to do is a declaration and you get as many as you need. So in one of my construction cases, I think opposing counsel is up to like 268 or something like that for interrogatories. So there you go. The parties may agree to more interrogatories by mutual agreement or application to the court. But parties also agree to no more than 10 depositions by plaintiff and no more than 10 depositions by LVMPD as provided in Rule 30. So I would be surprised if LVMPD needs more than 2 depositions. One for Chilli and one for Chilli's expert. So the problem, Pat's Cats, is that Chilli's will not be qualified to be his own doctor. His testimony about what physical harm he experienced is not going. I mean, he could testify I was in pain, but he can't testify that as to what actual medical conditions they inflicted on him, or how it's likely to affect him in the future, or anything like that. You'd be like, oh, they really hurt me, and that's great, but that's not money, and he's looking for money, so he's going to need an expert. Like $1, here's your $1. If he wants more, he's going to need an expert. Extension of any date or modification of the discovery plan. blah, blah, blah. Later appearing dates. So amended pleadings by 4:15, disclosed experts 3:15, rebuttal experts by 4:15, discovery cutoff date 5:15, dispositive motions by 6:14, and pretrial order by 7:15. Easy peasy lemon squeezy. The judge signed it, so that's good to go. And then we already went over the appeal, and then Chilli wants time to file a second amended complaint. All right, and then Springer. I don't want to cover Springer. Oh, Lord. I don't want to cover Springer. What's it we can do? So there's 2 responses to motion, and then there's... What are you? Have I done this one yet? I don't think I have. Are you a fan of Wasp at all? That's a band, right? Is Wasp a band? That should answer your question. All right, we're going to skip. Legal standard. A motion for leave to amend should be granted where the amendment will yield a meritorious claim. Courts generally refuse leave to amend only on the showing of undue delay, undue prejudice to the opposing party, bad faith or dilatory motive, failure to cure deficiencies by amendments previously allowed, or futility of amendment. A proposed amendment is futile if the complaint, as amended, would be subject to dismissal. Moreover, in determining whether to grant leave to amend, a court may consider such factors as undue delay on the part of the plaintiff in raising the claim, bad faith on the part of the moving party, and undue prejudice to the opposing party by virtue of allowance of the amendment. Ultimately, whether to grant leave to amend a complaint is within the discretion of the district court. No, Nasty Nate, I am not a KISS fan. AC/DC is a better band, but that's not really my genre. Plaintiff's proposed amendments would be futile. This is not going to be a good argument, I'm going to guess. While Rule 15 provides that leave to amend a complaint shall be freely given when justice so requires, the district court may refuse to allow the amendment if it would be futile. An amendment to a complaint is futile if the complainant can prove no set of facts in support of his amendment that would entitle him to relief. A proposed amendment is also futile if the complaint, as amended, would be subject to dismissal for any reason, including that the amendment would not survive a 12b6 motion to dismiss for failure to state a claim. Courts are justified in denying motions to amend as futile if the proposed amendment cannot withstand a motion to dismiss or otherwise fails to state a claim. That's right. They amended their complaint. They took out the TRO request, and they added in allegations about what did they add in the allegations about? They added in some really shit tier about allegations about I don't remember. It wasn't good. I remember going over it, and it was terrible. Rule 12b6 permits dismissal of a complaint for failure to state a claim. To survive 12b6, complaint must be pled with sufficient facts taken as true to provide plausible grounds. To discovery will reveal evidence to support the plaintiff's allegations. A claim has facial plausibility when the plaintiff pleads factual content that allows the court to draw the reasonable inference that the defendant is liable for the alleged misconduct. However, a pleading that offers labels and conclusions or a formulaic recitation of the elements of cause of action will not do. Plaintiff's proposed amendment is futile because he fails to state a viable claim under 1983. Plaintiff's complaint and proposed amended complaint contain vague and conclusory allegations that defendants violated his First Amendment and due process rights, but lack sufficient factual detail to meet the plausibility standard to survive motion under 12b-6. I don't understand why they keep going to other things. Like, why don't you start with your big gun, and that is judicial immunity. Judges have judicial immunity. You can't sue the judge for what they've done if they've done it in anything other than an administrative role. And I'm pretty sure that the defense can make a very good claim that those orders were done in a judicial capacity. So I don't understand. I don't understand. Why aren't they talking about judicial immunity? I mean, Iqbal's a great argument, but like, you start off with judicial immunity because that's your big winner, and then you need to get down to the less likely to succeed ones, like Iqbal or Twickball, if you really want to. The acoustics in this room are awful. We'll go in a different room, Blue. A claim has facial plausibility when the plaintiff pleads factual content that allows a court to draw the reasonable inference that the defendant is liable for the alleged misconduct. Plaintiff must bring forth more than mere conclusory allegations to establish a claim under 1983, yet fails to identify which of the allegations in his proposed amendment include facts sufficient to support his claims beyond a speculative level. Importantly, this court has found that the plaintiff has failed to fail. Importantly, this court has failed, or this. Importantly, this court has found that the plaintiff failed to satisfying his burden of establishing a likelihood of success on the merits of his claim. For the purpose of the TRO, or preliminary injunction, I should say, the court did find that the plaintiff failed to satisfy his burden of establishing a likelihood of success. But that's different than, for the purpose of filing a amended complaint, the court's ruling on the original complaint does not affect what the court, and likelihood of success on the merits is different than having sufficient factual allegations. What the fuck is this attorney talking about? What the fuck is this attorney talking about? This is a non sequitur. This has someone's talking about I needed some baffling. I'm pretty baffled with why they put that fucking sentence in there. The amendment to plaintiff's complaint would be futile because plaintiff has further failed to allege facts that would sustain claims of a violation of the First Amendment and due process given his vague allegations of misconduct. Plaintiff does not address the elements of each cause of action, and any superficial restatement of the elements of his claims are insufficient. While a complaint attacked by a 12b-6 motion to dismiss does not need detailed factual allegations, a plaintiff's obligation to provide the grounds of his entitlement to relief requires more than labels and conclusions and a formulaic recitation of the elements of a cause of action will not do. That's Twombly. Why did he split up Iqbal and Twombly? Why two paragraphs in this? Here, plaintiff's proposed amendments contain conclusory labels that do not meet the minimal pleading to be considered factual allegations. Like, what ones? State them. Plaintiff relies almost exclusively on Missouri v. Biden. Oh, that's right, that's the one. But I thought Missouri v. Biden was on a preliminary injunction. The actual Missouri v. Biden was a preliminary injunction because the government was exercising control over social media platforms to force them or cajole them or influence them to uh, silence or reduce the uh, reach of various posters who were saying things that the government didn't like. But I thought that was in support of his preliminary injunction motion for, I think he still called it a TRO, but it would be a motion for preliminary injunction. However, this Fifth Circuit case is not binding on the Tenth Circuit. The case is distinguished, and I'm guessing this case is distinguishable from Missouri. And normally, what you do is if you're going to use a shortened name, Missouri v. Biden, then you'd like put a in parentheses and then in quotes you'd write Missouri. That way, the court knows that in the future, if you use an italicized Missouri, you are referring to Missouri v. Biden. That's normally what you would do. In Missouri, a group of social media users and two states alleged that federal officials had coerced social media platforms into censoring certain social media content in violation of the First Amendment. The officials were employees of the White House who had allegedly flagged content on social media, monitored those platforms' moderation activities, and urged social media platforms to curtail misinformation, with should be quotes around misinformation. That is not the case here. In contrast, plaintiffs disrupted court business and harassed court staff, which resulted in a reasonable restriction of his access to the Seventh Judicial Court. And isn't it the Seventh Judicial District Court? Isn't it the Seventh Judicial District Court? Seventh Judicial District Court. Yeah, not Seventh Judicial Court. The plaintiff's allegation that, see, if you're going to put the in front of plaintiffs, you have to put the in front of defendants. Plaintiff's allegation that defendants have engaged in a campaign to have his content suppressed is completely unsupported by the facts in the record, and his reliance on Missouri similarly lacks legal analysis as to how it remotely applies to this case. That's right. He alleged that on information and belief, court employees contacted YouTube to have them strike his content for misinformation. But it was a link that he had posted in the description of the video to a Google search that is what actually got the content flagged, and so he removed that link or contested it, and he got the content put back up. So it's not. So it was a really stupid allegation to make because he didn't show how the Seventh Judicial District Court actually coerced YouTube into doing it. He couldn't show that they exercised some control over YouTube or influence over YouTube or threatened YouTube or anything like that. And in fact, the content was restored, which really undermines his whole case. Like, okay, even if they tried to do it, they were unsuccessful. But did they do it? I mean, I don't think so. Plaintiff's motion should also be denied because defendants are entitled to qualified immunity. Why qualified? It's not qualified immunity, you fucksticks. It's judicial immunity. Why? Oh my God. It's judicial fucking immunity. Defendants filed a motion to dismiss, which outlines multiple bases for failure. Failure to state a claim, lack of proper service, lack of jurisdiction under the Rooker-Feldman doctrine, qualified immunity, and sanctions for spoliation. Yes, Mr. Caruso, this is from an actual attorney. even if plaintiff were to plead any plausible facts to state a claim against defendants, and even if plaintiff were to properly serve an amended complaint on defendants, which defendants deny, the other deficiencies remain. If you were to, they would deny it? Like, I don't understand that. Even if plaintiff were to plead any plausible facts to state a claim against defendants, so arguendo, if you pled plausible facts, and even if you were to properly serve an amended complaint on defendants, which defendants deny, assuming arguendo that you are in the future able to eat dinner, which I deny, that's fine. Well, Papa Sanser, this is the 7th Judicial District Court's attorneys. So wrong party, Papa Sanser. Yes, Jeff. Judicial immunity is much stronger than qualified immunity. If a judge does something in his capacity as a judge, not administrative, but as a judge, making an order in a case, and there's a case number, and the judge made an order in a case, then judicial immunity. Bada boom, bada bing. Thank you very much. Bada boom, bada bing. That's a really fucking stupid sentence, by the way. Plaintiff's proposed amended complaint would still be subject to dismissal due to defendant's immunity, Rooker-Feldman, and spoliation. The spoliation claim is that after filing this lawsuit, James Springer decided to go ahead and delete all of these fucking videos and shit in his normal course of business, but that's still fucking spoliation. So you done fucked up, and he admitted to it, of course, because why wouldn't you admit to spoliating evidence? Nonetheless, plaintiff has failed to make the requisite showing they are entitled to amend their complaint under Rule 15, and the proposed amendments are futile. Well, accordingly, plaintiff's proposed amendment would not survive a dispositive motion, and leave to amend should be denied on the basis of futility. Plaintiff's proposed amendments do not relate back to the date of the original pleading. Right. So what they should be doing, these should be a supplemental complaint. Unless, and I don't think he did, but unless he alleged facts that were or should be in effect at the time of the original pleading, alleging things that happened afterwards should be in a supplemental. Like, after I filed this, I couldn't have filed these supplemental claims because they hadn't done them yet when I filed the original one. Remember all Chilli stuff in Chilli versus Abrams. There was a lot of supplemental things that they're doing because new instances of copyright violations were popping up post filing of the complaint, and so they were supplemental. FRC P15 provides the applicable law to determine whether the grant plaintiffs leave to amend. The amendment to a pleading relates back to the date of the original pleading when the amendment asserts a claim or defense arose out of the conduct, transaction, or occurrence set out or attempted to be set out in the original pleading. The purpose of 15C1B is that a party who has been notified of litigation concerning a particular occurrence has been given all the notices that the statute of limitations were intended to provide. So long as there is a factual nexus between the original and amended complaints, the amended claim is liberally construed to relate back to the original complaint if the defendant had notice of the claim will not be prejudiced by the amendment. In Benton, the court summarized the law governing the application of the relation back doctrine as follows. As a general rule, amendments will relate back if they amplify the facts previously alleged, correct a technical defect in the prior complaint, assert a new legal theory of relief, or add another claim arising out of the same facts. For relation back to apply, there's no additional requirement that the claim be based on an identical theory of recovery. On the other hand, amendments generally will not relate back if they interject entirely different facts, conduct, transactions, or occurrences. It is a matter committed to the district court sound discretion to decide whether a new claim arises out of the same transaction or occurrence. The relation back doctrine has to do with statute of limitations, and I don't think that there's an issue with statute of limitations because the alleged facts go back to January, and we're in November. There is no way in hell that New Mexico has a less than 1 year statute of limitations on personal injury. It's probably 2 years or thereabouts. It's at least a year. So there's no statute of limitations issue. So I don't know why they're talking about the relation back doctrine. Like there is no statute of limitations issue. Who fucking cares? Now the allegations they're making are that subsequent to the filing of the complaint, subsequent to that, the court did bad things, but so it's a supplemental it's a supplement to the complaint, not an amended complaint. But why can't they amend their complaint with it? I don't understand. It doesn't change anything. You know what I'm saying? It doesn't fucking change anything. And another thing I don't understand. Hold on, let me do this. Download that. Do that. And go back. So they filed their motion to dismiss on October 26th. And he filed his motion to amend and correct. Why did he file a motion to amend? He has 21 days as a matter of right to amend his complaint after they file a motion to dismiss, right? Because had they answered, was there an answer? Did they file an answer? Motion is set aside. They had 10 days. They had till the 23rd, and it was a motion to dismiss. So there was no answer. They just filed a motion to dismiss, which the court they split it into two, which was really fucking stupid. They filed two motions to dismiss because they're fucking incompetent. The court said, no, you can't fucking do that. And so they filed a single motion to dismiss. So they had 21 days, right? Twenty-one days. 21 days. Oh wait. Oh shit. I'm normally so in California you have time after if someone files a demur, you have time to file an amended complaint. You either file an amended complaint. I'm mixing up California and federal. Huh. No, I'm right. I'm fucking right. I'm fucking right. I don't know. I'm right. Amending is a matter of course. So if the pleading is one which responsive pleading is required, 21 days after service of the responsive pleading or 21 days after service of a motion under 12B. So again, so 21 days after, let's say the earlier of the two, 21 days after October 21 is, let's just for shits and giggles, like November 20th, roughly. Or no, November 12th, roughly. No, hold on a second. Shit, math. Let's say 15th. But they filed their motion to amend on the 2nd. So there's like, they didn't have to file a motion to amend. They could have literally just amended it as a matter of course. Why? Why must you be so fucking incompetent? Both sides are so fucking incompetent. Both sides are fucking incompetent. So we're talking about a statute of limitations issue that's, it's not uncommon for a motion to be filed shortly after a motion for leave to amend the complaint. So if he just had amended as a matter of course, there would not be the original complaint would go away. It would no longer exist as far as anybody's is concerned, as far as the court's concerned. And so the motion to dismiss would have gone away. So in June, he filed a 1983. In January, he filed a motion to dismiss. On February 6th, he filed a motion to amend. So what happened in this case, which is different than what is happening in the instant case, in Springer's case, is that he waited more than 21 days. January 2nd, 21 days. There's 31 days in January, right? So like on February 2nd or something like that is when he would have had, January 23rd would be 21 days after, right? So we had until January 23rd. He missed that deadline. Oh God, the incompetence. It just makes everything harder when everybody's this fucking incompetent. So I have a feeling that because he could, I don't know what the court's going to do. This is like locking two retards in a closet with like boppy sticks or something like that and just letting them go at it. And you don't know who's going to come out like on 2 feet. Just this is so fucking painful. This is like worse than Chilli. Chilli knew he could amend as a matter of right. And every time someone would file a motion to dismiss, the initial motion to dismiss, he'd file an amended complaint. So yeah, in that case where the plaintiff had missed his window to file his amended complaint as a matter of right, as a matter of course. And see, that's what I don't understand. Like, if Springer's attorney had just filed the amended complaint, not the fucking red line. Oh, Jesus Christ. See, it's so hard to figure out what the court's going to do because this is so messed up. What the court will, I want to make a prediction. I think the court is going to be like, oof, you had a right to amend, to file an amended complaint. So I'm going to allow you to file an amended complaint. You can't file the red line amended complaint because you're retarded. But you can file an actual amended complaint as a matter of course. So go ahead and do that. That's what I think the court will do. But the court might say, no, you don't get, I'm going to actually rule on the merits of this because you were too fucking stupid to file an actual amended complaint. He attached a red line amended complaint as an exhibit. The district court conducted a futility analysis and decided the motion for leave to amend, assuming the facts in the proposed amended complaint were true, and concluded the dismissal was warranted even if the complaint were amended. Yes. But then there's that other point where the court is probably not stupid in this case. And the court is probably going to say, well, you know what? Judicial immunity is going to apply here, even if the defense is too fucking stupid to raise it. Even if the defense, who is representing judges who are fully fucking aware that they have judicial immunity, is too stupid to raise judicial immunity, even in that case, judicial immunity applies. And so you're going to fail, even though the defense was too fucking stupid to raise it. The 10th Circuit affirmed the district court's dismissal and agreed with its reasoning. Thus, where it assists the orderly and expeditious resolution of the case, it would be appropriate for this court to consider defendant's motion to dismiss and plaintiff's motion for leave to amend the complaint concurrently. The issues raised in the pending motion to dismiss are pertinent to the futility analysis in deciding the motion for leave to amend complaint. If defendant's motion to dismiss is found to be meritorious and leave to amend would not correct the deficiencies, the claims against defendants must be dismissed. That's a fairly good argument that now, as it stands, being in front of the judge with a motion to dismiss, it makes sense that the court would then consider whether or not they have pled sufficient facts to survive a 12b6, even if the 12b6 says qualified immunity instead of judicial immunity, even in that case. Alrighty. And then we have this response to motion. See, this is the problem when people don't name things correctly. So this is a response to a motion, and then this is the response to a second motion for temporary 17 pages. All right, so I'm gonna call it that they're going to say that this is essentially a disguised motion for reconsideration, and yeah, that's what I'm going to go with. Factual background, yada yada. Factual background. Legal argument. Incorporation by reference. The basis for the plaintiff's second TRO motion is the same as his first TRO motion. Therefore, defendants incorporate their arguments from their response. They don't fucking argue that it's an improper motion for rehearing. Oh, Jesus. Oh, Jesus. Oh, Jesus. They've already done a motion for reconsideration. They tap in a few more alleged facts. And then they ask for the same thing again. Oh, okay, so we have more arguments. Oh, thank God. Oh, thank God. Oh, please, please. Yes! Oh, thank God. Oh, thank God. Oh, Jesus fucking Christ. Oh, thank God. They argued it. They argued it. They argued it. We're good. We're good. We're good. I can unwad my panties now. I apologize. I apologize for having wadded up my panties prematurely. They should have said it somewhere up ahead. Like they should have said it's going to be these issues that we're going to raise. Oh, the court doesn't have jurisdiction because of the appeal. Yes, there is an appeal, isn't there? And it confers to the Court of Appeals and divests the district court of its control of these aspects. True. Uh, and then that's good. That's good. That's a valid point. Second motion is a proper motion for reconsideration. Absolutely. Absolutely. Motion for reconsideration on 59E. Yep. They've already shot their wad. They're not pleading any new facts or law that they see. They can't just plead new facts and new law. It has to be new facts and new law that they would otherwise that they could not have otherwise raised at their initial hearing. So like new facts would be like if the defense had been withholding facts from them, and then all of a sudden like discovery comes out, and it turns out that the defense had improperly withheld this evidence from them, then that would be something that they might be able to plead, right? Or if there is a intervening Court of Appeals decision which changes the law and makes it so that they should have won, then they could say, oh, here's new law. It can't be just we couldn't find this law or we were too incompetent or lazy to find this law. It has to be new law, right? So it's they're barred. They've already had their motion for reconsideration and etc. This is actually a third bite of the proverbial apple, or maybe the fourth if you count the appeal. They still fail to meet the requirements. Unlikely to succeed on the merits. Issuance of the injunction will injure defendants. These are the same ones they've raised. Injunction will not irreparably injure plaintiff. Great. It will harm the public interest. Yes. Restriction of access was and is still reasonable. Sure. Conclusion. There you go. All right. Thank fucking God. Thank God. That wasn't that bad. All right. Okay. We're good. We're good. I'm relaxed and calm. Now, a response in opposition to motion. I don't know what the fuck we got. See, that's all right. That's the one I'm talking about. So you have response to opposition. Oh, he even called. So I understand that some districts, circuits, etc., do it differently. The way I have learned it is you have the motion, you have the opposition, and you have the response. So you automatically know where you are in that chain. Motion, opposition, response, maybe a reply, motion, opposition, reply, something like that. The response would be like petition and response. But the opposition to the motion, like those are the two, motion and the opposition are the two major things, right? So Freeman, Springer, his attorneys call this, they file this as a response in opposition to motion. But like they have a response to motion up here, the defense does. Now you have a response in opposition. Like this is an opposition, or no, this is a reply. This is a reply brief. This is a reply brief. But you see, because they're all fast and loose with these titles, now he calls this a response to motion to dismiss. So what is this, the opposition or is this the reply? More James Madison. No one fucking cares about James Madison, bro. Wokeism. Phenomenal. Wokeism. Just make the same arguments again and again and again. Mischaracterize factual averments in motion to dismiss. Defense motion isn't correct on certain factual statements or misconstrues certain facts, which plaintiff addresses and clarifies as follows. All right. Well, let's. Where is their motion to dismiss? 6th. No, that's not it. Where was it? There we go. There we go. What is it saying? Contrary to paragraph 29, well, they haven't paragraphed their paragraphs. Oh, I guess they have paragraphed their paragraphs. The affidavit of service by Michael Tinker stating the order directing service and setting briefing schedule was served on the court clerk at the 7th Judicial Court in Estancia, New Mexico on June 9th, 2023. Doc 12, page 2. All right, we're going to look for Doc 12, page 2. Doc 12? Doc 12. Doc 12? Hold on. Doc 12? Document 12, page 2. Document 12, page 2. Document 12. Doc 12. Huh. 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 What the fuck am I missing? This is Doc 12. Are we going to count this page 2? All right. All right. So, contrary to paragraph 29, the affidavit of service of Michael Tinker certifies that the court's order was served on July 13th and not June 9th. Why does that matter? Why does that matter? What does that change? What does that change? What does it change? I don't think it changes anything. I think I just paid money for something that doesn't change anything. The date. I don't think anyone cares about the date it was served. So I don't think that changes anything. Contrary to paragraph 32, the 2 videos are still available. So that one does appear to be available, and that one does appear to be available. All right. Let's go to paragraph 32. The video's 6. That isn't available, and that isn't available. So KL or K1I3LL, K1I3LL FMUTE, FMUTE, FMUTE. Oh, YouTube / not YouTube.com, YouTube.be. Okay. So this one, great. This is YouTube.com, MZRV, NN1, YPQI. That's weird. What am I missing? What am I missing? Why are we different? YouTube.com, www.youtube.com. Why do I get a bad one on this? Because that one does say it's not available. That's fucking weird. But this one says it's available. Oh. That is different. That's a L. How does it? Sneaky. Because that shows a 1 there, right? That's a 1, Y. But if you look down at the lower left-hand side, this goes to a, looks like a lowercase ly. And those aren't 1s, those are L's. And see, K1, I3, 1, I, uppercase I. Jesus, ever-loving Christ. The defense attorneys suck. The plaintiff's attorneys suck. It's like a race to see who could suck the most and the hardest. It does appear that they not only they miskeyed links, but they fucking hit it. Like, see, it shows 1 there, but down in the actual what the link is. So they edited the link to show one thing, but to go to a different place. Like that. Oh, that's. Contrary to the statement of 36, plaintiff did not state that he deleted evidence. He stated that it was his practice to delete emails once read prior to receiving the letter. Well, where's your link to that? Where's your link to that? Right? Because he said this in a video. Document 29, Exhibit E. Let's go to document 29. Exhibit E. Maybe it's in the main doc. No exhibits in the main doc. Exhibity. Exhibity. Well, let's see. Let's see if you can't. Do. Where can I buy this again? Let's see. Let's see. There's only the one attachment. All right. So what is this? No attachment. That. What exhibit E? Fucking exhibit E. What fucking exhibit E? It only lists one attachment, exhibit preservation mark. I don't fucking know. I don't know. Bro, I don't know. So where did he say it? Where did he say it? Document 29, exhibit E. Ah! All right, well, let's go here. All right, exhibit E, and then we were at 1332 to 1433. I don't know if you guys will be able to hear this or not.
Send something to my attorneys saying that they want me to preserve all of my journalist materials for them, so that they can come and take those materials from me. They said that they need me to preserve all my journalist materials because they intend to come and try to bully me and take those journalist materials from me.
It's called discovery, you dumb shit. They wanted to do discovery. Like you can't make allegations and then destroy all the stuff that would prove what you said or didn't say. You dumb shit.
Including any private conversations that I've had with confidential informants. Because they know that there are people, not just within their police departments and their legislature, but within the judicial system in New Mexico that are giving me information. They already know it.
Conspiracy theory Springer.
It doesn't matter because I delete it all as soon as it's read. But
well, so that's spoliation. It doesn't matter whether he got the spoliation letter or not. He filed the lawsuit. He knew that he should have maintained that. He knew or should have known he was supposed to maintain it. He didn't maintain it, therefore, and he stated he didn't maintain it. Therefore, yeah. So it doesn't matter. This is immaterial. He said it was his practice to delete emails once read prior to receiving the letter. Yeah, but that doesn't matter. As soon as he filed the lawsuit, he was required to not delete stuff that is related to the lawsuit. Plaintiff has served the parties consistent with New Mexico rules annotated, I'm guessing, 1-004. Plaintiff respectfully addresses the raised arguments that incorrectly alleged service has not been properly made upon these defendants, specifically Rule 4. State service is accomplished, quote, by serving a copy of each in a manner prescribed by that state's offer serving summons or like process on such a defendant. FRCP Rule 4. Rule 4, FRCP. Like, what the fuck is wrong with you? It's FRCP Rule 4. Under the New Mexico Rules of Civil Procedure for District Courts, Rule 4 requires that service may be made upon the state of New Mexico or a political subdivision of the state in any action in which a branch, bureau, agency, department, commission, or institution of the state is named as a party defendant by delivering a copy of the process to the head of the branch, agency, bureau, department, commission, or institution, and to the Attorney General. Subsection 2, party in that service. Right? Here, a copy of this complaint and summonses were first delivered to the Chief Judge for the Southern Judicial District Court. But is the Chief Judge the head of the 7th Judicial District Court? It was delivered. And what does delivered mean? By hand, see, it's by hand delivery to the clerk, designed to receive documents, not service. Oh my fucking god. Oh my fucking god. Oh my fucking god. So, just for an example, in California, if you want to serve a corporation, they will have a designated agent, especially if they're out of state, they'll have a designated agent for service or process, right? But even if they're in state, they'll have a designated agent for service or process. And you have to deliver it to that designated agent for service or process by hand delivery if you're serving the summons, right? So if you go there and you give it to a secretary, unless that secretary has been authorized by that person to receive process for them, then sure. But in this case, the clerk who was designated to receive documents, i.e., documents for filing in the court, not for receipt of service or process. It's number one, is the chief judge the proper person to serve to file suit against a district court in New Mexico? That's question number one. Question number two is there a designated, is substituted service proper? And I don't think it is. Especially if they can't show anything to say. I mean, yeah, that is the clerk in the court, sure, but it doesn't mean that clerk has the authority. Like if the state wanted you to be able to serve the clerk and not the chief judge, they would have said you have to serve it on the head of that branch or on the clerk of the court, right? That's what they would have said, but they didn't say that. It is of equal importance to note that the receipt of that delivery to Judge Murphy, i.e., to Judge Murphy's clerk, on the same day can be confirmed because not long after the delivery of the complaint summonses was made on Ms. Rosendahl, upon information and belief, New Mexico Supreme Court Justice Shannon Bacon was witnessed by whom? Telling multiple judicial attendees to the annual New Mexico Judicial Conclave that she was convening a meeting to discuss a lawsuit that was just filed against the 7th Judicial District. That's fine. They're aware of it. Great. That doesn't mean that they were served. You could be aware of a lawsuit. You still have to be served. The state, you only get to sue the state under specific requirements. You have to meet, like the state puts burdens in your way in order for you to effectively sue them. Just the fact that the state knows that you filed a lawsuit against them is immaterial. You have to complete service. Upon information and belief, Murphy and Murdoch Poff were in attendance, and while it's plausible they did not deliver that. Well, it's plausible that defendant Rosendahl, did not deliver the copies that had been delivered to her for Murphy and Poff. Instead, notifying it's not a defendant's job to serve other defendants. You fucking moron. He's arguing, but they knew, but were they served? But they knew, but were they served? But they knew, but were they served? But they knew. It is far more likely. We're just going to guess. Now it's far more likely. We're just going to guess. It's far more likely that she forwarded the documents to the defendants, and thus delivery is confirmed to have been accomplished. This is a different section, huh? Under H. G, okay. H. Service upon state or political subdivision, and we're looking for H1B. 1. Service may be made upon the state of New Mexico or political state by or subdivision of state in any action in which a branch, blah, 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 is a named defendant by delivering a copy of the process to the head of the branch. Well, So what they're saying is that if you don't actually serve the head of the branch, but you give copies to another defendant, and that defendant's like, here, check this out. All of a sudden, service is complete. I, I doubt it. I just doubt it. I just doubt it. I just fucking doubt it. Be a nice try though. The disingenuous efforts at gamesmanship with service. Well, I don't know. I don't know if that's really gamesmanship. You guessing that the defense has been served because, well, you served one defendant, and you gave them extra copies to give to the other defendants, and so you just assume that those other defendants received copies. You just assume that it's likely, you say, with no fucking rationale whatsoever as to why. You just assume it, and then they're the ones playing games. They're the ones who are making disingenuous efforts at gamesmanship with service. Yeah, it's them. What is that? Was that you accuse your enemy of that, what you're doing, right? Fucking hell. Regarding whether or not delivery occurred should not be rewarded, as it displays a lack of candor with this court that should not be counted. It's your fucking job as the plaintiff to serve the defendants. It's not the defendant's job to serve each other. You dumb shit. Nor should the court waste the party's time with further inquiry into the matter. Let's just ignore whether or not service was completed. Come on, guys. It's a minor technicality. They're here now. Let's just ignore it. I mean, bah! Bah! Fucking service. Like, okay, I'm an attorney. Like, what does the law care about service? You know, that whole notice, that whole due process requirement of notice. Just hand wave that shit away, right? They're here now. Fuck it. Oh my fucking god. Killing time passing through says that doesn't prove they were even referring to this particular lawsuit. Right. And it's on information and belief. And it doesn't matter if a Supreme Court judge heard about it or was talking about it, because the Supreme Court judge is not a party to the fucking action. I heard Tammy down the block. She watches one of the defendant's kids. She was talking about this particular lawsuit. Well, I think she was. I mean, I can't prove that she was, but on information and belief, I'll just say she was. Because you're not going to fucking do anything about it. You're not going to fucking subpoena Tammy from down the block to verify whether or not she knew or didn't know. And I'm not going to do it, so we're just going to say on information and belief, and we'll just let it fucking hang out there like a fart. Meaningless, not going anywhere, smelling the place up. Not changing anything, nor should the court waste part of its time with further inquiry in this matter, such as requiring the deposition of how the Chief Justice to discover how she learned of the lawsuit the same day as it was delivered, along with the summonses to the defendants. So why does it fucking matter if the Chief Justice knew? Did you serve Mercedes, whatever their name is, Murphy? Did you serve her? No? Doesn't matter if the Chief Justice knew. Doesn't fucking matter. I hate these attorneys. Just to drive home the point that the delivery was accomplished. Like, if it was accomplished, then why are you saying, like, it was likely? It was likely. Where you were saying it was likely? Upon information and belief. And while it's certainly plausible, it's plausible that she didn't deliver the copies that had been delivered to her for Judge Murphy and blah, 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 instead of notifying the Chief Justice. It's far more likely. So it's likely, right? But you even admit it's plausible that she didn't give the documents. It is certainly plausible that she did not deliver the copies. And you know what? If you served me copies of a lawsuit for someone else, I wouldn't serve them with copies of it. I'd be like, yeah, sure, buddy, whatever. I wouldn't serve them with copies because as an attorney, I know what I might be exposing them to. And I wouldn't do it. And why would a judge do it? Judges are aware of how service works and of the requirements of service. Judges would know that. So why would she, literally, why would that judge do it? Now, the judge might have talked to him about it, been like, hey, I got these stupid ass documents. These fucking idiots are suing judges like judges don't have judicial immunity. Absolutely, Will Vomit. This guy this fucking dumbass attorney wants us to try cases based on rumors. Wants service of process to be done on, well, it's plausible that it wasn't, but it's likely that it was. Yes, this is all very stupid. And I have a new tank I'm going to be setting up today. I've been moving some tanks around in my fish room, and I will be playing with fish later. And I'll be going P2 because all that coffee wants to come out. Just to drive home that the point the delivery was likely, hashtag probably, hashtag may have been accomplished, hashtag if you can accomplish it by giving copies to one defendant and have them serve the other defendants on your behalf. Despite the lack of candor from the defendants that they received the complaint summonses the same day the process server delivered them. Delivered them, not served, delivered. Plaintiff respectfully offers the legal definition of delivery for the defense edification as, quote, the formal act of voluntarily transferring something, especially the act of bringing goods, letters, etc., to a particular person or place. Delivery. This motherfucker is citing Black's Law. He's not citing a case showing that this method of delivery is effective as service. As service. Are we looking for service? Service may be made by delivering a copy to the head of the branch. Okay? How is delivery made? See, it says here, personal service or process shall be made upon an individual by delivering a copy of the summons or complaint or other process. So it sounds like if you take his, you could just fucking, I don't know, drop it on their doorstep and walk away, crumple it up and throw it into their car window. Would that be service? Well, shit. I mean, he was driving his car the next day. He must have seen it in there. Find me a case. Find me a case that defines service by delivery like that. This is important because though no New Mexico jurisdiction, Judge Browning has noted that other federal courts in 10th Circuit generally do not demand, in italicized, strict compliance, but rather demand substantial compliance with service of process requirements. So is it substantial to hand a bunch of documents to one of the defendants and just fucking hope that that defendant delivers it to the other defendants? Is that substantial compliance? Can you do your own service? Do you have to hire someone, or to serve? Or I can't read it underneath that. Maybe I can see here. That fucking heart in the way, dude. I wish I could get rid of that. Generally speaking, you have to hire someone to do, or someone who is not you, who's over 18 and not a party to the case. Someone over the age of 18 and not a party to the case. Generally speaking, can serve process for you. Here, plaintiff has several times over demonstrated he's substantially required. That he's substantially required with the New Mexico requirement, substantially complied, I guess, with the New Mexico requirement for delivery of the complaint and summonses, quote, in a manner reasonably calculated under all the circumstances to apprise the defendant of the existence of the pendency of the action and to afford a reasonable opportunity to appear and defend. Yep. Reasonably calculated. I just served one defendant and just crossed my fingers and fucking hoped that defendant served the others, right? Plaintiff understands he bears, quote, the burden of establishing validity of the service, but a district court abuses its discretion in deciding whether to dismiss a case for untimely service of process if its decision is arbitrary, capricious, or whimsical, or if you have absolutely fucking no way of showing that you served the other defendants. Here it is important to note that though Rule 12b-4 is invoked, the defendants are incorrect and do not actually mention that there is a defect with the summonses in this matter. Rule 12b-4. Did they raise 12b-4? Insufficient process. They should have said 12b-5, insufficient service of process. Okay. Well, pot calling kettle black. They fucked up. Well, yeah. Under Rule 4H, plaintiff has made the prima facie showing that he delivered a copy of the summons complaint to Ms. Rosendahl and directly to Judge Murphy via her proposed text. Her proposed text? What the? And as admitted by the defendants, they received the delivery. There is no further New Mexico jurisdiction or substantive argument offered by defendants that supports that sort of hyper-technical strict compliance the defendants argue here. Like actually serving the person, handing the person you're serving the fucking summons and complaint is not really that hyper-fucking-technical. Hand it to them. Drop it at their feet. Make sure that they actually fucking receive it instead of handing it to one defendant and crossing your fucking fingers and hoping that it gets to others is not hyper-technical. That's like, what the fuck are you doing, bro? At a minimum, this appears to be a motion to dismiss based on expected special treatment the defendants themselves are not or should not grant to the defendants appearing in front of them. Defendants wouldn't require that people actually serve defendants in their cases? I don't know. Most judges do. Most judges do require actual service. Likewise, defendants do not dispute the delivery of the summons. You know what? We are going to. We're going to do that. So I'm off the screen because I have to pee. All right, we're back. You should hold hands and sing while I'm peeing. Yes, absolutely. I could think again. Soap smells nice. Okay. Likewise, defendants do not dispute that delivery of the complaint and sentences was accomplished on the Attorney General, but rather was not done just how they would like it done in this instance. So their argument was an argument by analogy. The defense's argument was an argument by analogy that the service by the text was not sufficient. Courts have generally held that the term delivery as a term of art requires more than service by mail, which probably also requires more than service by handing it to a different defendant and hoping that different defendant gets it to the judge. So they're saying that if you interpret the New Mexico Rule 4H the same way as the federal Rule 4J, mail would be insufficient, text email would be insufficient, and what do they call that? Telephone tag, where you hand stuff through would also probably be insufficient. Now, second option for service under 4J2, 4J, GHIJ. Interesting. So if you can't serve them by like handing it to them, you can file a motion for service through other means. Okay. 4J2, 4J. Oh, FRCP. FRCP is what we're talking about. 4J2. Hand delivering or delivering copy to the chief executive officer or serving copy of each in the manner likely by the state's law. Okay. So either delivering a copy by hand, that's what they mean. Service is personal service, like serving a copy, like, here you go. I'm handing it to you, not mailing it, right? Or serving a copy by state law. Can't rewind? I don't know what that means. Is that something I control? Huh. Can't rewind. Huh. Is that DVR in OBS? That might be my fault. That could be my fault. I didn't know what that did, so I did not enable it. I probably should have enabled it. Oh, my bad. I will allow DVR next time. I thought it was recording stuff on my side. I'm like, I don't want to record this shit on my computer. I don't want to stink up my computer with this shit. Likewise, they do not dispute to assert the delivery of the summons complaints was accomplished on the Attorney General, but rather was not done just how they would like it done in this instance. Well, what were they saying? So, the New Mexico Rules of Civil Procedure say that you could do it that way. Okay. There's not a single summons returned for the New Mexico Attorney General, nor were any summons even issued for the New Mexico Attorney General. Nor has the defendant demonstrated that the New Mexico Attorney General has been served under New Mexico's procedural rules by delivering summons for any defendant in complaint upon the Attorney General. All right, that seems to be a lot. Goddamn heart. That fucking heart. I swear to God. Why is it enabled on this? Like, obviously, I don't want to see the fucking heart. I don't know what that word is. Something does it NP. I don't know what that word means. I guess I'll eventually find out what that word means. Ooh, I can do this. Bump. Bow does it. Okay. Well, that was a wasted bump. All right. Rather, it was not. They don't dispute the delivery service. I think is what they're disputing. One would think an attorney would understand the difference between delivery and service, but I guess he doesn't. Rather, argue is not done just how they would like to have this instance. Again, there is no New Mexico precedent that supports the delivery consistent with NRMA 1-004E requires something other than what plaintiff did here, and it is apparent that plaintiff has substantially complied with the requirements. I don't know. I would have to look it up, but I'm going to assume that there are some courts somewhere who determined what this means. And just generally speaking, service requires you physically taking a copy and handing it to that person. Generally speaking, hashtag not all, some deviation exists, but generally speaking, you just hashtag or you just hand the defendant the thing. So like you'd walk into the New Mexico Attorney General's office and you say, "Hey, I need to serve the New Mexico Attorney General this document," and the gal up front would say, "I'm authorized to take it," and you'd be like, "Okay, cool. What's your name?" And the gal would give you her name, and you'd say, "Received per so and so." You write down her name, who says that she's authorized to receive it on behalf of the Attorney General, right? And that would be sufficient. No one would argue that. But what they're saying is you can't just hand it to one defendant and expect it by osmosis to get to all the other defendants and the Attorney General. Importantly, Derringer versus Turney stands uniquely for the proposition that service on the AG by delivery copy of the complaint summons is not a prerequisite for this court to obtain jurisdiction over these defendants. Well, let's see if we can't see what the hell we're talking about here. After the state engineer entered an adverse decision on his application for a permit to acquire water rights, appellant appealed to the district court. This would be something that a Western Ag attorney. What's the name of his firm? Western Agricultural Resource and Business Advocates, LLP. This would be something he would know about. All right. Seventh Judicial District Court dismisses appeal on the ground of lack jurisdiction over it because Derringer would not serve the other parties, Mick and Jennifer Chappell, and the state engineer within the required time. Derringer now appeals to this court and reverses the district court's order of dismissal and remand for post-decision hearing consistent with this particular statute. Long-standing over water rights. This is a notice of appeal. This is a notice of appeal. Holy Jesus fucking Christ. So there's a difference in how you would have to serve process and how you'd have to serve a notice of appeal. For example, Chilli filed a notice of appeal in his lawsuit, LDMPD lawsuit, and served it on opposing counsel. He didn't have to serve the individual petitioners, plaintiffs, or defendants, excuse me, in person. He could serve so all the time. So there's service of process. There's service of process, which is a due process requirement that you have to make someone aware of what you're suing them for and how much you're suing them for. In order for the court to be able to, because of the constitutional requirement of notice and an opportunity to be heard, they have to have that notice of what they're being sued for and how much they're being sued for before the court can enter an order that is going to be binding on them. But once the court has jurisdiction over them through the service of the summons and complaint or an administrative hearing, whatever, an appeal from that, there's a lot of administrative law. Like an administrative law judge will hear a complaint in a department or something like that. In this case, it was a state water engineer who had jurisdiction over the initial hearing, and then he issued an order. And if you didn't like that order, you had to essentially appeal it to the next court up, to an actual court of law, not a administrative law court. And so there already was jurisdiction over it. Though everybody knew of the existing underlying controversy, notice and an opportunity to be heard had been given. So the notice that was going to be sent out did not have to be done according to the requirements of the service of process. Appeals to a district court shall be taken by serving a notice of service process within 30 days. That notice is not the same kind of notice for a service of process. So you're talking about workers' comp cases. Workers' comp cases, you have an ALJ, an administrative law judge. And if you disagree with the decision of the ALJ, you can essentially appeal it de novo to the next court up. The court concludes there's no deprivation of due process rights where a claimant has been accorded an opportunity to be heard the informal hearing and affirmatively waived her right to a subsequent formal hearing through a written acceptance of the recommended resolutions. This is completely an opposite. I don't know why. I don't know why the fuck that they're raising this. This is not applicable. This case doesn't have to do anything with service by copy of the complaint and summons. It has nothing to do with service of a complaint and summons. Oh, Jesus fucking Christ. I feel like I have to explain this to Chilli, but these are actual attorneys. These are actual attorneys. Motherfucker. Defendant's argument the plaintiff did not allege personal participation is meritless. A simple review of the complaint highlights the ridiculous and meritless argument that the individual defendants do not participate personally, but before proceeding to examine those factual allegations, it is more important to note that none of the individuals are sued for damages. Actual damages against the 7th Judicial District Court, and then award of costs and expenses included. So they are on the hook for money damages. Theoretically. The complaint makes it explicitly clear that defendants Murphy, Murdoch, Poff, Jones, and Rossingall are sued under Section 1983 only for declaratory and injunctive relief. Thus, even though it unnecessary under Section 1983 jurisprudence to demonstrate personal involvement when the defendants are not sued for damages, plaintiff will proceed to highlight those allegations herein. Even though it unnecessary. Where does it say that? Like, where does it say that you don't have to demonstrate personal involvement if defendants aren't sued for damages? You're literally telling people that they can do or say something, or they can't do or say something under 1983, but you don't have to show that they're personally involved in order to get them to have to say or do something, or not be able to say or do something. Like space, like I don't get it. Space is fake. Like, why do I care about what you think? Night night, sweetheart. These complaint sections 15, 16, 17, 18, 19, 21, 25, 26 demonstrate allegations of personal conduct that are alleged to have violated plaintiff's constitutionally protected liberty. All right. So I'm assuming he's talking about that she signed a document, and that document bans him, I guess. I'm going to say yes. Sure. Complaint allegation 27 for Murdoch Poff. Okay. 27. Okay. Issued an order. Judicial fucking immunity. Defendant Jones, 19, 20, 22, and 23. So Jones served something, okay? He served a document. The letter describes the contents of the administrative order. He served it. Yep, he did. 22. He served another one. Yep. And 23. Yep. Well, he states the basis. He's just serving documents. The The court will serve documents from time to time. It comes from the clerk, and it's just the court serving documents. But okay, where was I? I was hell, shit. I scrolled up. What? Here we go. All right. Defendant Rosagall, allegation 28. On multiple dates, she refused service. She refused service. We need a declaratory relief that she has to serve him or something. I don't know. It doesn't make sense. Refuses service, having threatening letters served by state police, issuing administrative orders, and denying access to public hearings, all establish a deliberate, intentional act on the part of defendants, each of them individually, to violate plaintiffs' civil rights. Apparently, sorry, Ralphie. Apparently, I didn't turn on DVR, so you can't scroll back. But this is just this is Springer's attorneys responding to the opposition by the 7th Judicial District Court's attorneys. No, that. Oh, this is a response to a motion to dismiss. Response to the motion to dismiss, 57. Why do you call it? Yeah, this is an opposition to motion to dismiss. Plaintiffs do not plead for damages under Section 1983 such that qualified immunity is not applicable to this case. Interesting, because my understanding would be that judicial immunity would still apply. So I don't know why we're talking about. I don't know why everybody keeps talking about qualified immunity. Because plaintiff artfully and carefully pleaded that he was only seeking declaratory, prospective, injunctive relief against the defendants. Oh, that's right. Well, so the rule against, hold on a second, the rule on 42 U.S.C. 1983 actions, you can only get declaratory relief in certain instances. 42 3. Except that in any action brought against a judicial officer for an act or omission taken in such officer's judicial capacity, injunctive relief shall not be granted unless a declaratory decree was violated or declaratory relief was unavailable. So they can get injunctive relief only if declaratory relief is unavailable. That's right. He didn't. Interesting. Well, we'll see. In this regard, I want to look at this again. I want to look at next. Next is 87. E. Where the fuck was attorney's fees? I forget. I'm apparently forgetting which one gives you attorney's fees. One of these. I thought it was like 1985. Well, that's conspiracy. So 1987. Yeah, 87. Uh, huh. So he's essentially seeking a Monell claim against the 7th Judicial District Court, and he's trying to get the 7th Judicial District Court to pay out the damages. Huh. I'd have to look up to see if Monell will allow you to get damages from. He even addressed judicial immunity here. Judge is not immune from liability for non-discretion. Actually, I'll take it. These are fucking orders. See, he even they knew they talked about judicial immunity. Interesting. In this regard, the Supreme Court and the Tenth Circuit have been completely clear that qualified immunity protects government officials from liability for civil damages insofar as their conduct does not violate clearly established statutory or constitutional rights of which is personally known. Qualified immunity is applicable unless the official's conduct violated a clearly established constitutional right. A qualified immunity is unavailable in a suit to enjoin future conduct. Therefore, this court should only assess whether qualified immunity applies if plaintiff have brought claims for damages against individual defendants in their individual capacities, which he specifically did not. It is just against the Seventh Judicial District. Then there's this. Sorry, I swung out of frame. Defendant's only argument the court should not exercise supplemental jurisdictions based on faulty premise that qualified immunity applies to suits seeking prospective injunctive relief. But again, injunctive relief is not available unless declaratory relief is unavailable. And he did seek injunctive relief. He sought injunctive relief because he sought literally an injunction. The Supreme Court has stated unequivocally that defendants are wrong under the premise and without any other justification, the plaintiff's Civil Rights Act claim against the entity authorized by New Mexico law to be sued for violations of the New Mexico Bill of Rights arising out of the same conduct should be allowed to proceed under supplemental jurisdiction. Well, citation needed, I guess. Perhaps if defendants had actually followed the law and the rules of civil procedure for New Mexico district courts to open an actual case for contempt, the Rooker-Feldman doctrine would apply if plaintiff were asking the court to review a decision made in the case had it ever existed. But defendants never did that. They attempted to open a criminal prosecution as retaliation for plaintiff's actions, but ultimately that case was dismissed by the special prosecutor, see ECF document number 33-1. 33-1. You guys are killing me, Smalls. I'm glad I didn't read this. I never even saw this particular pleading. I don't know what's going on. Adam, in response to your question. Where are we making allegations about this notice of non-prosecution? I don't see where they raised the issue of it. Maybe I just missed it. Where did they mention exhibit? So they're alleging that this was the criminal contempt proceeding that was initiated in the 13th Judicial District Court. Okay. And this was on the first day of September. What was I looking at? I was looking at first day of September. Let's see, response of 5. So somewhere around 32. Sorry, I'm getting as apply. Response of 5. What was it? See, response of 5. 865. Matters pending. Okay. So this was served on the 5th. But when was it written? I mean, so we got the notice of non-prosecution. That was issued on the 1st, and they signed it on the 5th. But who really fucking cares? So where were we? How did I get on this? Perhaps if defendants had actually followed the law and rules for civil procedure for New Mexico District Court to open an actual case for contempt. Well, apparently they sent it to the prosecutor for a potential criminal contempt. The Rooker-Feldman doctrine would apply if plaintiff were asked this court to review a decision made in the case had it ever existed, but the defendants never did that. Well, there are cases that are open. That's how you get orders. That's how orders were issued. Case numbers were open. They attempted to open a criminal prosecution as retaliation for plaintiff's action, but ultimately that case was dismissed by the special prosecutor, CEC. Well, it wasn't dismissed. They got a notice of no prosecution. It's not necessarily done with prejudice or anything like that. So it's not dismissed. Well, let me rephrase that. This case number is probably dismissed, but it doesn't necessarily mean that it was dismissed with prejudice. This is non-prosecution, nolle pros. We saw that in William Kaiser's case. The prosecution moved to dismiss the case, which the court did, and that meant it was with prejudice, and then the prosecution had to come back and say, hold up, we intended to do a nolle pros, or non-prosecution. And that's what this is. So it's not dismissed with prejudice, it is nolle pros. It can come back, essentially. It can come back to get you. Thus, as defendant cites, district courts do not have the jurisdiction over challenges to state court's decision in particular cases arising out of judicial proceedings, even if those challenges allege that state's court's actions were unconstitutional. But the Rooker-Feldman doctrine has no applicability to the conduct of state's courts outside particular cases, and in fact, the Supreme Court has specifically recognized the validity of the type of case plaintiff brings here, stating that for this reason, the Virginia court's members were proper defendants in a suit for declaratory and injunctive relief, just as other enforcement officers and agencies were. Supreme Court of Virginia versus Consumers Union of U.S. Maybe, but there are cases. That's why when you look at at this. There are case numbers associated with. See, there's a case number. Maybe not that one. That was a DB one. That can't. That's it. It is 3, maybe. See, filed. There's case numbers right there. Those are case numbers. And what was the no pros on? No pros is 722. Hold on a second. Hold on a second. Hold on a second. Hold on a second. There are 4 cases open, apparently. 4 cases. And he got a null pros on 1 case. 1 case. There might be other cases open. There might be other cases open. I don't know why I keep going back to that one. Because there's 4 cases. 4 cases. And only one of them you got a null pros on. Again, for the edification of defendants, nothing in either state court version or federal rules of procedure provides for dismissal for spoliation. Technically, it could be like an evidentiary sanction if it gets far enough. But I agree. I don't think just for spoliation necessarily the case would be dismissed unless you could show some sort of a prejudice to your case. Nothing in defense motion regarding spoliation fits any of the 12 or the 7 defenses contemplated by Rule 12. And defendants cannot just assert a fact by mischaracterizing and warping a statement made by plaintiff to have the court construe there to be a failure to state a fact upon which relief can be granted. Probably correct, except it's not, because as soon as like the plaintiff is on notice, because he's the one who's going to file the case, he's on notice not destroy anything that might be relevant to that case, either for his side or for the defense side. The defendants, like if it's their standard practice to destroy things, they don't know necessarily they're going to get sued. But once they know they're going to get sued, once they have a clear knowledge they're going to get sued, at least Ninth Circuit, once they're aware they're going to get sued, they have to stop destroying things and preserve the evidence. That's why that is the point of sending out the spoliation, the non-spoliation letter. Generally speaking, you would send that out prior to filing and serving the lawsuit, just to put them on notice to stop destroying anything if that's their standard operating procedure. But the plaintiff knows they're going to file it. So defendants do not cite one single case outside of the discovery context where the court has dismissed the case, and certainly none of the discovery cases dealt with the case at the pleading stage of the proceedings. That's, normally it is a discovery sanction. This is a nonsensical red herring based on a made-up fact that is patently misapplying the law from discovery to Rule 12 motion. The misapplying law from discovery to Rule 12 motion is correct. The court should not be entertained or countenance this type of frivolous briefing. I don't know, man. I don't know. I don't know that his pleading is sufficient. I don't know. But this is 2 retards with wiffle bats fighting it out in a closet. You don't know which one's going to come out alive. And thankfully, that's all I'm going to go over today. Because, good God, I'm spent. That's what we just went through, right? And it was 68 that we just went through, right? Yep. All right. Anyway, thank you for watching, and have a great day. Now, if I go figure out how to end this thing.